All right. Good morning, everyone. Welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. So, Angela, can you please take roll?
Ali, Brown,
Present.
Coleman,
Present.
Shivers,
Here.
Desmond, Krieger,
Here.
Mercado,
Here.
Mohebi,
Here.
Munoz, O'Reilly,
Here.
Poindexter, Robbie, and Riley.
Here.
Yeah.
Okay, and next on the agenda is public comment.
Okay, for those who are participating by Zoom, please virtually raise your hand if you'd like to give a public comment. If you wish to address the committee, you'll be given 3 minutes to speak. For those who are participating by phone, you can press *9 to virtually raise your hand. There's going to be an on-screen timer that'll begin as soon as you start your comment, and you'll be verbally alerted once you have 30 seconds remaining. So if you'd like to give a public comment, please use the raise hand function at this time. All right, I'll go in the order that the raised hands are received. So first we have Maria Grijalva. Maria, you have 3 minutes to speak. Go ahead.
Can you hear me?
Yes.
Okay, thank you for having this meeting, and thank you for your efforts to bring responsibility, a sense of responsibility to the legal profession in California. My name is Maria Grijalva. I am a complainant and a complaining witness, and I received a letter from the complaint review unit for a complaint I had against Jeffrey Reisig, the Yolo County District Attorney. I hope you have heard about this case. What happened in this case is that in 2018, I was registered as a political PAC, and I donated money against the district attorney, Jeff Reisig. I donated about $43,000 to his opponent, a public defender. And so shortly after that, within days, actually months, I was arrested falsely. And of course, I was never found. In fact, the judge dismissed the charges. And so the bottom line is that I filed a complaint and nothing came of it. And in 2022, he did it again. He contacted the state Attorney General's office and told them that my PAC was doing this and that and this and that, and that they needed to open an investigation against me. And so they actually did that. But then I ended up contacting the DOJ, and I told the person in charge, I said, that's a conflict of interest for a state employee to be involved in political activities. And so they stopped that investigation. So anyway, so now I've contacted every legal professional. I don't see the clock on here. I've contacted every legal professional that's registered with the bar in California and several out of state, asking them to represent me to do a Walker petition, because that's the next step that I'd have to do. And believe it or not, nobody has signed up. Everyone has told me, no, we defend bad behavior. We don't protect the public. And basically that was the message. And so I needed all of you to know this information. I needed to put this in public record so that, the public knows that prosecutorial misconduct is protected by the state bar. And basically that's what I've seen. And so I still don't see a timer, but that's it in a nutshell that I needed to share with you. My name is Maria Grijalva. I live in West Sacramento, and this complaint was against Jeff Reisig, the Yolo County District Attorney, and I hope that your efforts to bring civility to the legal profession is successful, because it's really an embarrassment. We are an embarrassment. And so anyway, thank you so much for listening to me.
Thank you, Maria. Up next, we have Gibson. You may start, when. And you're on mute, guest Gibson.
Am I here?
We can hear
Yes.
you.
You know what, I'm actually on my phone as well as the computer, so I'm gonna make a quick statement. I don't think there's more to this, but I'm gonna make a quick statement to make sure it's on the record. My name is Carrie Tony Gibson, and I'm suffering from severe depression and anxiety. I'm a victim of anti-Black hate crimes, fraud, and the cover-up of the fraud. Multiple court officers, judges, law enforcement, the Committee on Professional Responsibility, and the court reporter, Board of California, are a party to the anti-Black hate crimes, fraud, and the cover-up. California is the most anti-Black state in this country. Judges such as Judge Sarah Heidel, Judge Bruce Albuquerque, Judge Lawrence Riff, who's in bed with the California Reparations Task Force. On September 23rd, 2020, Judge Sarah Heidel sent City of Industry law enforcement to break in my home, 8:30 p.m. at night. Officers put my son and I in the street, threatened to arrest us if we didn't leave our home. City of Industry illegally took possession of my home. Los Angeles court illegally sold my $1.5 million home during COVID. My white abusive alcoholic husband, who has ties to the family court, stole all my possessions valuing over $500,000 and gave them to storage. I recently discovered a picture of his attorney wearing my jacket. Judge James W. Gibson, my husband, gave over $500,000 of my property to Box and Go, who, after receiving payment for over 3 years, stole my property. I attempted to file a complaint with the court via ex parte. The judge refused to hear my ex parte. I researched her on a state bar website where I learned that this judge didn't have an active law license. I made multiple correspondence with the Committee on Professional Responsibility. The Committee on Professional Responsibility is a party to the anti-Black hate crimes, fraud, and the cover-up. I made multiple requests to the Committee on Professional Responsibility, who did nothing, who did what they normally do, protect the anti-Black hate crimes and culture in the state of California. I requested that the Committee on Professional Responsibility identify the panel who reviewed my complaint. I never received an answer. The only positive response I received was to file a motion to change a venue, which I did. The judge took that motion off the calendar as they had done multiple times. I failed to mention that Judge Sarah Heidel illegally deemed me vexatious. I made multiple attempts to get remedied via the appeals court. I hired an appeals attorney who I'm in the middle of filing a formal complaint. His name is Clifford Snyder. He did nothing. He stole my $10,000. My son and I lived in a bed bug infested hotel for over 3 years, the Comfort Inn in La Puente, where we went through an illegal eviction by the West Covina court. I'm assuming my time is up. I just wanted to put this on the record because, again, I'm a victim of anti-Black hate crimes by the state of California. It's my purpose to demonstrate that California is the most anti-Black state in this country. I'm a victim of government-sanctioned trauma, terrorism, and attempted genocide. Is my time up?
Yes, it is, Carrie. Thank you for your public comment. We appreciate it. All right, next we have a guest who I'll allow to talk from area code 626. Go ahead and start. But please unmute yourself. Are you there, guest from area code 626?
You'll need to unmute your microphone by pressing *9.
Okay, I don't have a response for the unmute. And there are no other public comments after that. Cassidy.
Okay, so 626 going once. Okay, so let's move on then. Oh, okay. Is 626, are you available to make your public comment? No? Okay, let's move on then. Okay, so the next item on the agenda is approval of the minutes from the last meeting. May I have a motion, or are there any corrections or modifications to the open session minutes? If there are no corrections or modifications, anybody have any corrections or modifications of the minutes? Nope. May I have a motion and a second?
Motion to approve.
Second.
Second.
Oh,
Okay. All right, Angela, please
Sorry.
take the roll.
Who was the second? Was that Nima? Okay, thank
and Raquel, but
you. Right.
Yes.
Thank you.
Okay, I'll take the vote for the minutes. Ali, Brown,
Yes.
Coleman,
Yes.
Guzman, Mercado, Mohabi.
Yes, sorry about that.
yes.
Thank you. Munoz,
Yes.
O'Reilly,
Yes.
Poindexter,
Yes.
Rondi, Riley, Shivers.
Yes.
Thank you. The motion carries unanimously.
Okay, next on the agenda is my chair report. I don't have anything to report, so we'll go on to the staff report, which Erica will present.
You. Hi, everyone. Good morning. It's the last day of January, which I think for everyone is great news at this point. I know many of you are LA based, and so I hope everyone has stayed safe and things have calmed down a bit down there. What I'd first like to do is give a brief update on the appointment cycle, which we talked about at our December meeting, but I have a bit of a timeline update and can give you more information there. So the appointment cycle is set to begin in early February at this point, which is likely next week. And there are 3 committee members that have term end dates in late 2025, and that's when we will be recruiting for starting in the 2025-2026 cycle. And then, of course, Brandon, as our advisor, will also be terming off. Once the appointment cycle officially begins, staff will be sending a communication to solicit interest for the vice chair position with the committee. And then, of course, we'll also let you know so that if you have any colleagues or others that you know who may be interested in applying to join COPRAC, you could certainly send the information along in regards to COPRAC, as well as there's many other committees at the State Bar as well that will be seeking members. So if they're interested in volunteering to work with the State Bar with COPRAC, that's fantastic, but also with another committee, we would love to have them apply. Second, as we'll get into in more detail during our planning session, sub-entity review has been completed at the staff level, and those recommendations from staff will be submitted to the board at their February 2025 meeting coming up in a few weeks here. I believe several of you probably gave input and were reached out to regarding that, so thank you if you did, as well as past COPRAC members and past staff as well. There are several recommendations that I'll just talk about high level today. Just a reminder, those are recommendations. Nothing has been approved or even presented to the board yet, but we'll be going through some of those today during the planning session. And many of those are things that the committee is already in the process of implementing or has expressed a desire to implement. So I think overall, these are good recommendations for the committee. Finally, I do want to take a moment to discuss some staffing changes within the Office of Professional Competence, which is the office that staffs this committee that Angela and I and Kathy, who I'll introduce in just a moment, all work within. Angela and I will be moving into the Office of the Executive Director effective for me this coming Monday and Angela shortly thereafter. And I'm going to be moving into a new role with the State Bar, which is as a Deputy Executive Director, which I'm greatly excited about. Looking forward to the opportunity, but I will say, as Kathy and others know, in OPC, as we call our office, my first role with the State Bar was ethics related. I staffed the ethics hotline, and I've been focused pretty much on ethics in every job I've had at the State Bar in one way or another. So I'm hoping to continue that in one way, shape, or form in my new role, but I've just greatly enjoyed working on COPRAC related items. Even when I was on the ethics hotline, I got to work on opinions in what feels like a lifetime ago. So I've been greatly involved with COPRAC for a long time and hope to get to continue to do so in one way, shape, or form. In the short term, Angela and I will still be around and you'll still see us at meetings. The plan is for us to continue to assist in staffing COPRAC at least through the symposium, if not thereafter. And so we will be doing some cross training and you'll get to know other members of the team because a lot of the work that you do with us is, you know, based on our relationships that we've developed over time. And I'm excited for you to have new relationships with new staff. And that's a great segue for me to introduce Kathy Ungiri. She will be taking over as the program director for the Office of Professional Competence, also effective this coming Monday. I'll let her give a larger introduction, but she's currently the managing attorney until the end of today for the Office of Professional Competence. And she leads all of the proactive education development within OPC, all of the MCLEs and other resources that are on the State Bar website, as well as directly supervises the ethics hotline. So she's well suited to take on this program director role. And so Kathy, if you want to give a little bit more of an introduction, please go ahead.
Yes, can you hear me okay? Okay, thank you so much for welcoming me, everybody. I have been at the State Bar for a few years and I came on to really do the proactive and preventative education for the State Bar. Prior to my time at the State Bar, I did staff the Judicial Council's Providing Access and Fairness Committee. So I'm quite familiar with committee work and I'm happy to be kind of getting back into it. Additionally, I did, while I was at the Judicial Council, I did judicial education in the area of ethics. And so I developed one of their ethics education programs that is required by all the judges. So I have a lot of familiarity on that side as well. Prior to working at the Judicial Council, I've been an attorney for, well, now I've been an attorney for about 16 years. So just really excited to work with all of you and to get to know, you know, all the work that you're doing and to continue the great work of this committee.
Thanks, Kathy. We're really excited to work with you and sad to see Erica go and Angela go, but you're still going to be around lurking and helping us. So congratulations, both of you, on your promotion. Congratulations, Kathy, on joining us and your promotion as well. And I'm really excited for this year, I think. And thank you, Erica. I think we're going to move into the planning portion. And Erica really and Angela put a lot of work into organizing the documents and the PowerPoint that we're going to take a look at. So this is really their labor of love to get us off on the right foot for 2025. Okay, so what do you want to do, Erica? You want to share your screen or?
Sure. So I'm going to share the posted PowerPoint presentation and Cassidy, if you'd like to walk us through it, and I'll quickly advance to the next slide.
Okay, so before we get started, I just want to go over kind of an overview here. The goals there's about 4 goals here that we are going to try to achieve through this planning process. So first, we want to establish a working group to finalize recommendations for content that is for formal ethics opinions, articles, and then explore if there's other means of guidance that we can be putting out there on a regular basis. We also want to establish a working group to prepare recommendations for a process for selecting new topics for opinions and articles and whatever else we want to issue opinions and guidance on. We want to establish a draft work schedule that provides for the annual deliverables for the committee. So we're holding ourselves to account and being realistic about how we are getting things done and what time frame. And so, for example, we want to recommend 2 formal opinions that are adopted by the board, 3 draft opinions issued for public comment, quarterly ethics articles, 3 to 5 articles. So those are kind of the, timing wise, and we'll get into it a little bit more once we go through this. And then finalize our 2025 work plan that we will need to vote on today, I believe. Okay, so the agenda that Erica just took off the screen.
Sorry.
That's okay.
Got ahead of myself.
That's okay. So I just want to orient myself, make sure I'm covering everything here. So we're going to review the COPRAC charge, review our 2024 accomplishments, review staff prepared sub-entity review recommendations, discuss opinion versus article options, and then develop the work plan. So, okay, next slide. Okay, so what is our charge? This is kind of just to orient everybody here. We need to address matters involving professional responsibility to facilitate compliance with licensees and their ethical duties. So that should always be on our mind when we're thinking about opinions and issues and things that we want to put out there. So as part of that, we're going to draft advisory opinions on issues of professional responsibility, study and recommend changes to the rules of professional conduct, draft arbitration advisories, providing guidance to fee arbitrators, administering attorney-client fee disputes under the mandatory fee arbitration program, and then provide outreach and education. So we've got the Symposium, there's always CLEs that we're solicited for, and then our ethics alerts and things like that, other types of educational materials that we can be putting out there. Okay, next slide. So what did we get done last year? I think we did pretty well, considering we didn't have a work plan or anything really, structurally in place. So let's just kind of go through some of them. We did the ethics of in-house counsel. We have a draft pending, and there's actually 2 opinions that grew out of that, so that's good. We've got our colleague impairment opinion and a revised opinion that was adopted. Succession planning was adopted, and then we have the standard of review and fee disputes with the written fee agreement. Sorry. Okay. And then what we have issued out for public comment are the flat fees and termination. We have a draft pending there. Conversion clauses, although I don't know what I'm sure we'll talk about that soon. I don't know what the status is of the conversion clauses opinion. We have the determination of a reasonable fee, a draft is pending there, and then the other ethics of in-house counsel draft pending. And then we put on the ethics symposium, which many of you participated in, and was very successful with 572 attendees and participants.
Cassidy, can I just, there's one other accomplishment that I was not included here, and that was the committee also spent time evaluating Model Rule 1.16 and the amendments that were made to it as it relates to vetting essentially prospective and current clients. And ultimately that led to a recommendation to the Supreme Court not to move forward with adopting the Model Rule version. So just wanted to point that out as well.
Yeah, and and then I also think that we did get those comments done on the judicial threats. Those were, I think we got that done in record time, basically, and it's ready to go out. And we'll talk about it for this meeting. So, we were busy last year, but now we want to kind of have a little bit more organization to that chaos, because we all have other jobs, but we should have a better kind of schedule. Okay, next slide. Okay, sub-entity review, staff recommendations. So these are the staff recommendations for sub-entity review: develop a mechanism for COPRAC to issue short form guidance without requiring Board of Trustee review. So we are in the process of doing that through the ethics alerts. I don't know if there's anything else though on the table for something like that. but we can explore that. Increase staff support to reduce draft reliance on committee members, which that has happened over the past year, and I think we should continue with that. Rescind the prohibition on co-prac addressing UPL issues. I don't know the status of that, but yeah, that's a goal. Develop a process whereby co-prac solicits California attorneys on areas of interest and need for ethical guidance, and require co-prac to develop annual work plans for approval by the Board of Trustees, which we're doing right now. Okay, next slide.
Sorry, too far. And I'll just add, just for context here, so these are staff recommendations, just so we're clear, based on input that the committee received as well as staff. So this is not Angela's recommendations or my recommendations, or even recommendations from the Office of the Executive Director. It's kind of a amalgamation of everyone's responses for those who provided input as it related to co-prac, just to give you a little more context there.
Thanks, Erica. Okay. So here is kind of what we were drilling down a little bit more specifically on the short form guidance. So on our opinions, you know, these are the kind of things that we need to consider when we are trying to decide between opinions and articles, or whether to issue an opinion on a particular topic. So we want to look at the complexity of the issues, the need for need for in-depth analysis and nuance. You know, we can talk about a number of examples there where we've had some very complex opinions that are difficult to get out the door. The importance and impact of the legal practice. So, you know, are they broadly applicable, or are they too narrow? So, you know, we want to have that kind of debate. Application of rules to hypotheticals and scenarios. They're longer, they have a more authoritative voice, and what is the benefit of, and taking in the benefit of public comment and public input. So the opinions are, you know, more robust. They, you know, we would be tackling broader issues or more complex issues where there's not a lot of guidance. And you know, for that reason, they're going to take longer, but you know, you'll see that we want to have the track for an opinion should be about a year, and we'll get into that timing in slide. And then for articles and alerts, we want to tackle emerging issues, whether or not, you know, look at whether or not there's an urgency to it, so it's something we want to put out quicker. We want to highlight an issue that we want to bring to the public awareness, whether there's further analysis or an update needed on an existing opinion. Maybe it's something that we're raising an issue, but it's not necessarily, or we're not necessarily able to solve any kind of problem. There's no, or solve any type of legal question. And then these are shorter, obviously, and then, you know, less authoritative, more guidance, maybe more best practices type points. And then we want to address, is the issue that we're looking at, you know, something that can be covered by both. So, you know, is it something that's difficult to provide definitive guidance? There's a lack of consensus, there's a lack of clarity in certain practice areas, but not others. Is it something that we should be providing practical guidance on, risk management issues, and whether or not we could be helpful in providing preventative measures or explaining preventative measures on the particular issue. Okay, next slide.
Yeah, Kathy, if you don't, let me just say, so what exists here is, these are all, I'll just say, suggestions, and largely came out of looking at existing like our opinion inventory, right? So there's 209 opinions that exist from co-prac, some of which are you know, 50 years old, and some of which are brand new. And so looking at what's in those opinions and how they've been done, obviously the ones that are older are much more succinct, and as frankly, the world has gotten more complicated, so have ethics opinions from the committee. We also looked back at articles and alerts that have been issued either by the committee or by individual authors who happen to be on the committee, or former members, and then just as also from staff. And these are kind of this is the universe of those opinions, or articles, excuse me, essentially. So these are what kind of came out of those as thematic elements. None of this is to say that any of these things have to be in any of these particular categories. And I also will say that as it relates to the staff recommendations, it's possible there could be something else, right? So we have formal opinions that require a significant amount of work, and they take a significant amount of time, largely because of the public comment process. What we'll explore later in the agenda is what is envisioned to be an article, which has none of that, and will be done, has been done, and will be issued likely fairly quickly comparatively to formal opinions. And so the question I think for the committee to explore is whether that's sufficient. Should there be a third option that is something that kind of hits the middle ground between there, or if having just opinions and articles and alerts is sufficient for what COPRAC is trying to accomplish.
Okay. Okay, so based on all this, we want to develop a work plan based on our goals and the information that we want to be putting out there. We need to put together work plans. So we need to determine our annual work product goals, reviewing our existing opinion inventory. And then we need to determine if there's interest in taking on new topics. So explore requests from stakeholders, review strategic plan for new topic alignment, and review new opinion topic input from the committee if there are new topics. So we're gonna need to go through our inventory, which is fairly large. So let's move to the next slide. Okay, so Erica, I think you're going to take on the rest of just this kind of macro, broader overview of the bar's strategic plan.
Yes, and this is again just for kind of level setting, so that we kind of know if the committee's desire is to focus more on what's in the strategic plan as we get to the sections that would be applicable to COPRAC. For what it's worth, I think that COPRAC already fits very well within the strategic plan as to what just developing opinions, but we can certainly talk about that in more detail. So very high level, there are 5 strategic plan goals that exist. We're going to focus primarily on goal 3 when we get to it, because that's where most of COPRAC work fits in. But I did want to share all of the goals with you as a reminder. Back in, I believe it was October of 2022, our executive director, Leah Wilson, did meet with the committee and introduce the strategic plan at the time that had been adopted by the Board of Trustees. So for those of you who were on the committee at that time, this may look a bit familiar. At that time, there were only 4 goals. Goal 5 was introduced in 2024 and adopted by the board at that time. Okay, so very high level, there are, like I said, 5 goals. The first is strengthening the attorney discipline system. The second is enhancing access to and inclusion in the legal system. Number 3 is regulating the profession, and we'll get into why that's where COPRAC's work fits. The 4th is engaging partners, and the 5th is protecting the public through innovative use of technology and responsible data management. Within that, the State Bar has a foundational principle that we are committed to advancing diversity, equity, and inclusion within our own operations and within the legal profession as well. Okay, so goal 1 is largely, the work of the Office of Chief Trial Counsel, the prosecutor's office. So it's to administer an attorney discipline system that is efficient, accountable, and transparent. Goal 2 is to enhance access to and inclusion in the legal system, and that's through outreach and education, as well as improved access to legal advice and services, and a legal profession that reflects California. And so this is an area in which COPRAC's work and the Office of Professional Competence as well, we do have some work in this area. And so I think this is an area where the committee could explore if they want more of its work to be here. Traditionally, COPRAC's work has been focused on educating lawyers on their professional responsibility obligations. Our office has kind of taken a little bit of a a slightly different path in some areas where we are focused on educating lawyers, but we're also now focused a bit on educating consumers of their rights and their ethical obligations that lawyers have to comply with. And I think that's relevant here because we have been spending a lot of time talking about how our opinions may be inaccessible to some people because they are so long and so dense, and that's attorneys and consumers, of course. Attorneys maybe don't have time to read a 30-page opinion, and consumers may not want to either. And so I think that's something to perhaps think about as we're exploring the work of the committee overall. And then goal 3 is really where a lot of the work of the committee kind of fits in, and it's to promote the ethical and competent practice of law and to prevent misconduct by providing education, resources, and support to the legal profession. So that's every ethics opinion that COPRAC issues, every arbitration advisory, and every MCLE program that the committee produces or speaks at. And so what I think the Office of Professional Competence and COPRAC is really focused on is really upstream work. So if you're thinking about it, we are trying to keep people out of that downstream discipline system for 2 reasons. One, we don't want attorneys to be disciplined, and of course, most importantly, to protect the public from attorneys who may be engaged in violations of the rules of professional conduct and other ethics obligations through common law and statutory law. Goal 4 is to engage with partners and stakeholders to enhance public protection, and then to restore the State Bar's credibility, reputation, and impact. That's in part from some of the Girardi issues that this committee is very familiar with and has discussed quite a bit. And so what this could include is collaborating more with other local bar associations. It could involve working, with other ethics committees in a more formal fashion, perhaps. And so that's something where we could explore that as well. I know that several members of this committee are on other ethics committees with local bar associations. And so, sharing resources and confirming no one's working on the exact same thing at the same time, I think is an area that is probably already happening, but we could be more formal about it. And then the last one is to strategically invest in and implement a technology infrastructure, cybersecurity, and next generation tools. This is really an internally focused goal for the State Bar, but I do think it's relevant here because this committee is exploring, generative AI and responsible use of it. We have, other opinions that are touching on use of technology, cybersecurity, and so forth. So just wanted to flag that as well. And then I'm just going to go back to goal 3, because like I said, we're kind of going to focus most likely on that area. And so this is work, again, that our Office of Professional Competence can take some of the information that we have and bring it back to you. So using data to identify attorneys that are most at risk of misconduct, we spend a lot of our efforts looking at the top types of complaints that the Office of Chief Trial Counsel receives and working on education in those spaces. And then consumer focus. Our office is currently developing self-assessments for attorneys to be more aware of their ethical obligations. Obviously, the committee hosts the Ethics Symposium, and many of you already speak at other education events. And then practice tools and other resources beyond opinions and articles, if that's a space that you want to consider. And then supporting the development and retention of attorneys within the legal profession. Oh, sorry. Getting. Okay. Are you guys getting me back? Okay. Let's see who. All right, I'm gonna keep going. I think it's gone. Okay. Sorry about that. And then policy and systems change to possibly implement regulations that will address and deter actions that pose risks of significant public harm. That's something that this committee actually already has done when it looked at the CTAP rules, when it was developing 8.3 and those types of things. So I'm not sure there's a great need for that at this time, but certainly something we could explore. I'll also say that I think the judicial threats work that the committee is going to be looking at later today is an area that's within this space as well. So a slide with a lot of text, but here's kind of the more detailed implementation steps that the State Bar has done in this space. I'm not going to go through it all, but again, it just really focuses on, developing more resources for attorneys and making those resources accessible to attorneys and to consumers. And I think that's an area that the committee may want to focus on as part of its planning strategies today. So with that, I think that's all of the slides. I will stop sharing. And the committee can decide if they want to have a discussion. I can take notes, and we can certainly go from there. Thank you.
Thanks, Erica. So do we want to start, well, we have a couple of documents here, the work schedule and the opinion log. And did everybody have a chance to take a look at those? The draft work schedule, the work plan, and then we have the opinion log. Yes, no.
I see nods, and then Raquel has her hand up as well.
Oh, sorry, I'm looking at two screens. Go ahead, Raquel.
I can, I have some questions, but you can finish whatever you're saying and I'll come after you. So I don't want to interrupt you.
Okay. I think what we want to do is go and we'll get back, I'll have you ask your question, Raquel, but we want to go through the opinions, right? The opinion log, and just kind of prioritize and pull through them. And then once we decide what opinions we're going to pursue, then we can look at the work schedule and plug them in, right? Erica, is that a reasonable approach?
Yeah, so I think there's a few things that could be done here. So the draft work plan, which is a blank, essentially, there's nothing in it, is an area in which the committee can decide what they would like to accomplish as far as if you want to prioritize any of the existing opinions. There are several that I think are likely to be ready to be submitted to the Board of Trustees this year. There's one arbitration advisory that's very close. So the question is there anything else that needs to be done in that space? And then beyond the symposium, if there's any education that the committee wants to explore, as well as those kind of like ad hoc things that were in the slides as it relates to should there be formal recommendation as to what should be in an opinion versus an article. At our December meeting, there was a lot of deliberation about what should fit into those categories. And then, exploring whether or not the current methods for soliciting opinion topics should remain, or if there should be something different done there.
Right. So we're plugging in. We're picking the topics for everything and plugging them into a work plan, right?
Correct.
Okay. Okay. Raquel, shoot. What's your question?
Okay, probably questions for both Erica and yourself. So I'll start with you, Erica. The sub-entity report, is that going to be available? Is that going to be public? Are we going to be able to see that, and how?
Yes, so it will be public. It will be closer to the board's meeting in February, is my understanding. I'm going to say it's my understanding because timing of things at the board meetings can of course change. So just like this committee, the board issues its agenda 10 days in advance of the meeting. The meeting is set for February 20th and 21st. So we should be expecting the agenda to be posted around February 10th, and then the materials typically follow thereafter, again, like this committee. And once that is posted, I can circulate it to COPRAC so that you can review it. And provide input. To my knowledge, the recommendations will not change, that will be contained in that item. It's for other committees as well, not just COPRAC. But of course, what the board decides to do with those recommendations, I can't predict at this time.
And then in terms of, there was either 4 or 5 that staff is recommending. Can you just give some context as to what's the thinking, what's the thinking of that? What's the benefit? One in particular stood out to me is input from attorneys. And so I'm just curious of how you all thought about all of them, but that one in particular, given, you ask people for input, that they typically think that means you're going to do something. And
yes.
So, the challenge input doesn't mean, people hear it as, oh yeah, they'll take it up. And so I'm just curious how you thought about all of that.
Sure. So let's just go through the 5 quickly, I think, just in order. develop the mechanism for short form guidance. I hope that one and staff support are not much of a surprise to the committee, only because we've been talking about this quite a bit. But the thought here being that, there are areas in which I think the committee should perhaps be issuing things more quickly to the extent it can. The AI guidance was something that was done very quickly. Judicial threats is something that's being done quickly. Those are two different formats than the committee is used to working through. So the practical guidance was done within less than a year, but it didn't go through a formal public comment process. It was approved by the board, but it was something that's different for this committee. And then the judicial threats would be an article. That's something that the committee has done, but not for quite some time. And so the thought here being that there are just things that come up that need to be addressed more quickly than over a year or two or more. And that's why there's that recommendation. And tied to that is that increase for staff support. I feel like I say this at nearly every meeting, but we do as an organization recognize that this is a committee of volunteers and that there's a lot of work involved in being a member of this committee. It's not really a committee where people can just kind of show up and vote on things. There's a lot of work that occurs in between meetings and drafting and research and so forth. And so the hope here is that staff can continue to be involved in areas where the committee sees fit. I think there's a few ideas here that could be kind of at the front end and at the very end, and perhaps the middle is something that the committee wants to retain ownership of, if you will, or the staff could be even more involved in that and kind of sit in on working group meetings and take back recommendations from the working group and kind of be working on the drafts more so than they currently do. The UPL prohibition, this has been discussed at this committee quite a bit over the years. And so COPRAC since the mid-1990s has been prohibited in addressing the unauthorized practice of law. And this is frankly a challenge for the committee, and it's an area that I think many attorneys want more guidance in, especially now that there's a lot more remote work. There's, implications with technology. We spent a lot of time working on the Gen AI items as to like at what point is a generative AI product engaged in the unauthorized practice of law, and who is responsible, if that's even the case. And so I think this is an area in which the committee has wanted to be able to discuss it a bit more and feels constrained by the board resolution that prohibits it from doing so, other than saying in a footnote that the committee cannot address issues of UPL because of a 1990s board resolution.
So what is the status of that? I mean, what?
The status of that is just this. So it's a recommendation to remove it. And that's it. I will say that there are, if it is removed, we're going to have to figure out the process here because there are antitrust implications associated with this. So if this committee and ultimately the board is saying something is or is not authorized in this space, I don't know if there was a dental board case that came out, 10 plus years ago at this point that kind of is an area that addresses this. And so it's going to be an area where we're going to have to figure out to what degree COPRAC opinions that touch on UPL would need to be reviewed by perhaps the general counsel's office and beyond. So that's an area that I think is going to take a bit of a workup that would ultimately be something that's recommended to the board as a process for that particular area that is perhaps more robust than the current process for other ethics opinions that COPRAC does.
Have we looked at what other state bars do? Because other state bars issue UPL opinions without any, well, I assume without any issue, but do they have the same antitrust issues that we have to hurdle?
Yeah, I mean, they should. It's federal, it's the federal law. So I think that to my knowledge, that has not recently been explored. It was about 10 years ago, I believe. But because there was no recommendation to change the current practice at the time of not addressing UPL, I'm not sure that there was a plan in place that was pursued in any way. But I think that's something that this committee and the Office of Professional Competence and other offices at the State Bar would be exploring if the board wants to move forward with that recommendation.
And
Okay, but
what do you think is the current board's openness to the idea? What's your
I don't
Okay.
have a sense. I would be really
Oh,
speculating.
you don't? Oh,
No.
okay.
Yeah.
Right, so but we
You
so-
never ask a question you don't know the answer to, Erin.
So we shouldn't
be
be
a big
putting
one.
we shouldn't be putting a UPL opinion on the work plan just yet. It's kind of the
I would say
status.
probably not.
Right.
Yeah.
Okay.
Yeah.
All
Okay.
right.
The next is to develop a process for co-practice solicit attorneys on areas of interest and need for ethical guidance. So how that currently works is we accept opinion requests. They're few and far between, and then this committee either staff does a short workup on them, or it's something that the committee just looks at and decides what to do with. It's typically an individual that submits that request, so it's not necessarily clear that that's like the needs of a larger population for an area of advice. And so I think the thought here is just that there could be different ways of soliciting input. I'm not sure that there's a sense of how to accomplish that, but I think that's an area where we would be exploring, how should they come through? Should they come through bar associations, or is that just kind of gatekeeping in this area, and so forth? I think that used to be a way that COPRAC got a lot of its opinions. If you look at our old rules, it was, the questions are, has this already gone to a local bar association, and did they decline to address it? And I'm not sure that that's the current. A lot has changed since that rule was adopted, and I think so it's looking to explore other ways to solicit opinion, the need for opinions.
And I'm embarrassed to ask this question, but how do they actually submit requests for opinions? Is there like a portal on the State Bar website, or like what?
Yeah, essentially by email is actually how it happens. And so Angela and I get them. Our website suggests that they need to be submitted by mail. So sometimes we get them by mail still. But they are typically at this stage by email. And then, as you know, the requester is confidential unless they choose not to be. And so we redact that information and then submit it to you to decide if you want to take the opinion up.
Okay, so we want to discuss, is there a better way to do that? Do we want to put out more outreach to see, to a more organized way of soliciting requests? Although, well, I have a opinion about that, but we can talk about it when we get to that.
And then I have one last question for Erica and then for you, Cassidy. The last one, I guess it's Erica, because I think you were presenting, but I don't remember. What's the distinction being made between articles and an alert? On the listing, it was not separated. So I have an idea what I think it is, but what does it mean in the context of what you're sharing?
So it's just how they were labeled when they were posted to the State Bar website, essentially. So some of them are posted as alerts and some of them are just articles. Oftentimes the articles included questions that an attorney could answer to get continuing legal education credit. So that's kind of the distinction, but there's not very many of them, and they are frankly quite old at this point. There's a question as to whether or not they should just be archived on our website. But that we looked at those as they exist currently, and what you saw on the PowerPoint was essentially just themes that exist in those old articles and alerts.
Okay.
I mean, we can make a distinction if we, we have the freedom to figure out what kind of output we're going to be deciding on. So an alert, we can do both. An article can be a longer guidance type thing, and an alert can be just a one-page issue spotting type, alert that can go out more frequently. So those are the kind of things that we could be talking about here. It depends really on whether or not we have the capacity to take on all of our good ideas that may not have a bunch of follow through. Okay.
So Cassidy, at the beginning, thank you, Erica. At the beginning, you mentioned making working groups doing a number of different things, and I realized you went quickly, and before I disagree, let me try to understand. What are you recommending and why?
Yeah, so I have a question about that. I mean, I think what we want to accomplish today is the work plan, right, Erica? So I don't know if we really need work. I mean, I think we want working groups to continue to monitor the schedule and come up with recommendations for new topics and that sort of thing. But you know, I don't know if we want a working group to finalize recommendations to go into the work plan. And was that, I mean, I guess I'm asking for input there because, you know, we're not going to get much done if we're going to continue to have working groups to make recommendations for a work plan. And then the work plan is finalized like 3 months from now, and then we're in the middle of 2025. So I think we should just get it done today, right? Is that okay?
Yeah, I think
Yes.
I agree, and I think others agree. What I would say is that I think the thought here is that as it relates to opinions versus articles versus alerts versus whatever else you want to call it, there was a lot of deliberation at the December meeting, and the committee could decide. We kind of know what we want articles to be, at least as it relates to the judicial threats one. We know this is an article, we want to post it now. That being said, if there's more thought that the committee wants something more formal in this space, to say this is what fits in an opinion, this is what fits in an article, this is what fits in an alert, to the extent those two things are different, this is what fits in something else, whatever that else is, I'm not sure. That could be something that if the committee wants to make that decision today, that's fantastic. If the committee wants to have a working group of some kind, make recommendations that are presented back to the committee and something more formal is developed here, I think that's also appropriate. So it's really, you know, the sense of what the committee wants to accomplish today in that space, as well as it relates to if there needs to be a different way to get topics for the committee to be working on, recognizing that there's a very long opinion log that we're going to look at in a minute here. And then, so that's another area where that could be added to the work plan, essentially as tasks that the committee is going to accomplish over the next year, in addition to doing opinions and doing articles or what have you.
I do, real quick, and then Dan, go to you. I like the idea of having a working group to come up with the formal guidance on what's an opinion and what's a article or an alert. That doesn't mean that we can't vote out a work plan today because we don't have that definitive formalized guidance. But I think that it's a good idea just to come up with that so, you know, POPRAC committees years from now can rely on it, you know. Okay, go ahead, Dan.
I was going to say the same thing. I think the process that would be useful is to do both. So we should vote on a work plan today, come up with what we think are the numbers for articles, alerts, formal opinions. We know what formal opinions are. And then as we go, the working group that's looking at this can capture that experience and say, this is where it gets bogged down, or it should be longer, or whatever, but it shouldn't prevent us from doing something and making a plan today, I don't think.
Yeah. Anybody else? No other hands? Okay, so let's get on with it. Let's should we look at the opinion?
I think we should. I thought Erica had in something that wasn't presented, which I am an advocate of, is having a frame for which we're making decisions. So she had what I would call a sieve. So these are the criteria, because otherwise we're each coming with what is our hot button or whatever. So you didn't show it, but I did see it. And I think if we have any, to be effective, if we'll be better served with having it. Doesn't necessarily have to be the ones Erica put, but something versus just looking at them. No, the Civ, Erica, this is just a law, but you had the criteria, but that's not what you called it.
Making a decision?
Excuse me?
You're talking about like criteria on how to make a decision for picking topics, deciding between opinion and article.
No. It's to decide how to look at this basket of many years and decide which ones are in or out, versus we look at it and I have my hot button, so this is what I'm on, and Dan has his hot buttons, and everybody has their hot buttons, but so
Well,
one
right.
of them was,
Like complexity of issues.
One
Yeah.
is, how does it fit in the strategic plan? And if we
Was that on the
can't,
PowerPoint?
it
Was
was
it on the
on one of your, it was, how, oh, Erica, you don't know? It was your PowerPoint.
I have, unfortunately, I have 5 documents related to the
Oh.
planning session in front of me. So if you
I
can tell
know.
me which one, I can certainly share it.
Well, I read it, I didn't print it, because I thought you were gonna share it, because it seemed like it was so effective, but let me look at it.
Oh, maybe it's on one of the
Does no,
work.
does no one else recall it?
Is it on the work plan
value-
document or the work schedule document?
Yeah,
I
it probably was
remember-
with the work plan. It probably was. with
Yeah,
the-
I remember seeing it. I want to say it was in a PowerPoint, but
Yeah.
I don't remember how many PowerPoints there were.
Just the
One.
one.
Just one.
So that, yeah.
I mean, I'm thinking of, I don't.
Oh, here. I think maybe this is what you're referring to. And if it's not, then we can go from there. But let me get it out of this mode. But is this what you're talking about? The explore requests from stakeholders? I'm not even sharing. Explore requests from stakeholders review for new topic alignment. Is this the 3 or is it more than this? Oops.
Not on. Cassidy, I thought shared that.
She did.
Yeah, she
Yeah,
did. It's
but-
something that wasn't shared. I'll look in my email.
Oh, I
don't-
see. So it's gotta be one of the one of the documents on the, that was
It was.
part of the agenda,
Yes,
materials.
it was.
Okay.
Uh,
I'm going to try one more and then I'm going to give up.
Maybe it's on the schedule one?
Wait, Erica, you can't give up. It was your best work.
Thank you.
Well, I think it's the, I
It
think
was your
it's on
best
the
work.
draft co-prac work schedule, maybe?
Yeah, Angela sent it
yeah,
to us.
The
Let's ask
draft
it-
work schedule.
There's this right here.
Is it this?
Yeah, I guess that was what Cassidy said. Yeah, okay.
Okay.
It was, yeah, but it's a.
Oh, what's that? Wait, what is that? Come in, wait.
This is the guidelines this is a draft. So this is a draft. Guidelines for prioritization of proposed topics. And this is
Yes, which is what Cassidy said. Okay, so I
did?
skimmed over the top, but I mean, I think it's the same thing in terms of when we look at this long list of things.
What, is this a separate, when did you, is this?
Angela sent it, Cassidy.
Angela sent it.
Yeah,
Oh.
it was like 6 attachments that were in that particular email that she sent out.
Right. And to my mind, they're the way that collectively we can
yeah.
frame a
Yeah,
mind to say, this is in, or this is.
So
Yeah.
what this essentially is, for those who maybe haven't read it, is it's twofold. So one is, should this topic be taken up by the committee at all, right? So that's the first 5 questions, right? So, and this is relevance to the current legal environment, impact, frequency of this being an issue, complexity or lack of clarity in this space, and who did the request come from, which may also be relevant. And then if the decision is made to take up the topic, it is what format should it be in? Should it be in a formal ethics opinion? Should it be in an article or an alert, and again, or something else? And so I think that this, if the committee wants to move forward with a working group exploring these 2 paths of how do we decide whether to take on topics and how do we get solicitation or get topics, and then once we have topics, what do we do with them and what format are they in? This could be a starting point. This was just drafted by staff, and this was actually drafted, I will say, quite some time ago. It was when Sarah Bonola was our chair. And the committee was very busy at the time and had other priorities like dealing with 8.3 and the AI guidance and so forth. And so this was just not a high priority at the time to move forward with.
I like the idea of formalizing it. We are doing this already informally, like the opinion for, well, so here's an example. This Corporate Transparency Act was something that was submitted by a public member. We took a look at it and analyzed whether it was appropriate for us, and if so, in what form, and then decided it wasn't really an ethical issue that would be appropriate for us. But we also sort of informally determine what form, like the civility guideline is now an article. And so that is happening, but I like the idea of formalizing the process so that, as Raquel is saying, we can kind of put it into the system and then it goes through, as long as it doesn't get stuck somewhere, which is the risk.
I think this would also be really beneficial to those who are requesting opinions, right? So that they could see this, and this is how decisions are made, so that if they don't tune into the meeting where their topic is discussed, they're not saying, well, what on earth happened? They could see at least that these are the factors that were evaluated before deciding to move forward with it or to decline to opine.
Yep. And I have it. I'm not sure if it's really reflected here, but one of the other things that we would look at is like, is somebody else dealing with it, the legislature or something else along those lines, because we have deferred based on that in the past.
Yeah. Okay, so I think, at least for today, this is a good document to provide guidance and we go through the opinion topics. And so I think everybody should have this, if you have it open, if you have another screen like I do, maybe have that in front of you when we're going through so that you have this guidance on your mind when we're going through. I mean, is it relevant to the current legal environment, impact on attorneys? So those are kind of the checklist things that we should have in our mind as we're going through the opinions. Okay, so should we move to the opinion log? You guys want to take a break? Or you want to just go straight to the opinion log? No?
Let's roll.
Let's roll. Oh, God.
And just
We're deadly
clarify,
serious today.
Cassie, you're gonna go to the log and we're gonna say yay or nay. What are we?
Yeah,
trying to
I
do
mean, let's
here with
just
the
talk.
log?
Yeah, I mean, yeah, I think we should just start, go, let's at least put it up and see what, we're gonna just cross off ones we don't think we're gonna pursue. Because our goal is, what are we gonna, so we're gonna come up with 2 or 3 opinions to new opinions for the year that will get started. Let me look back at
So not to
And
over.
so do
Go
we
ahead.
even, I mean, we have so many that are still open. Is there some reason why we're adding?
Well, okay, I know, that's another question. I mean,
Why don't we just put the ones we haven't completed and say we're gonna get them done? And then if we have more time, then we can add new.
Well, if we're gonna stick with the schedule, which is within a year, we should be able to. I mean, we should be able to start a new opinion, at least one new opinion this year. I think that's a realistic goal, but let's first address the opinions that are at various stages and determine, what additional work is going to be needed to complete them. Like for example, the in-house counsel one, that one, I think it doesn't take that much more work to get out there, frankly, at least the one that I'm working on. And we need, we have the other one, but I'm not quite sure the status of that one, but those are like, at the end. But there's several that are not, so let's figure out which ones are basically new opinions that will take the full year. And then see if we have the capacity for an entirely new topic. Because there is something to be said for reinvigorating this committee, because I think we all kind of feel a little bit bogged down by, the same old opinion topics, I mean, we got to get it done and be, complete them, but we also, I think it'd be nice to have a new topic. That's just my personal opinion. You guys can disagree.
So if we approached it with an eye toward, let's pick one from the proposed opinions that we would focus on and put it in the pipeline, but make it a priority to finish the ones that are in progress to fill the working plan.
Yep.
That probably okay. So we don't necessarily have to go through the entire list. We can just hear people propose which one they think should be in a new opinion.
Based on this criteria. Yeah. Okay, well, let's go through then the first part of the opinion log, which is the existing opinions.
Okay, would you like, does everyone have it open? okay,
Yeah,
I will
could
share
you
screen.
share? Okay.
Yeah.
I'm not completely clear, but I'm gonna try to be flexible and see where it goes.
Okay, so
Yeah.
just
go
for
ahead.
context, so this is something that has existed, this active opinion log for about a year or so. Again, at our December meeting, we started to go through it and there was just a lot in here. And so it's now color coded, in the hopes that maybe it's a little bit easier. So everything in green is active in one way, shape, or form. So as you'll see, if it's had public comment, it shows here. It then shows kind of where it is. Pending what the working group is not very descriptive, but if it's already gone through a public comment, it's probably farther along, as well as if it's a second public comment, ideally it's close to being done. And then as we scroll through, all of these in this yellow color are actually things that at one point the committee wanted to take up as topics. As you will see, with the exception of Cassidy, no one who suggested these is still on the committee. So,
Well, yeah, sorry.
oh, well, yeah. So I'll just say, if the committee wants to take it, and they also, it says issues outline, but there's actually no action to my knowledge that has existed in any of these. So these are just topics at this point that the committee could decide to move forward with or put on hold
Or change, or
eliminate.
change to an article or an alert, like, so that's, like, I was thinking like, oh, I remember this deportation attorney topic that never got off the ground, but now I think it's probably a really good topic for an alert, given everything that's going on. So anyway, so I think, those are the kind of discussions that we should be having, but we should start, we have a lot of opinions in various different stages. So scroll up. So should we just go through each one, and for each of the lead drafter, let's just figure out where we're at. Because these are all gonna go on the work plan, because we're not gonna get rid of them, right? But we just need to know if we have the capacity to take on a new topic for an opinion. And then we should then move on to figuring out what topics are appropriate for articles. Right?
Cassie, as we're going through this, can we also make the determination of where the status is and what's the estimated time of completion? Because I think that will help us to make the determination on, okay, well, this particular opinion, we're at the stages that it is currently, should be completed by this time period. So then we know that we can kind of get that off our plate.
Yeah, exactly. And so let's just go through each one, but is there a way, I feel like I want to have the work plan up to, I'll just put it up on my own screen. So for the work plan categories on opinions, we have the strategic plan goal, the strategy, the implementation step, the work plan, the deadline, two boards sitting as, what's RAD, R-A-D?
Regulation and Discipline Committee. So that's who approves. It's essentially the Board of Trustees, because the Board of Trustees now sits as the Regulation and Discipline Committee, but that's who ultimately has authority to approve opinions for COPRAC.
Okay, so the question on that one is, has it already gone to the board for approval? Yes, no, date, and then priority. So if you guys have the work plan in front of you, then these are the questions that we should be asking for each opinion.
And I'll just say the three columns on the left, so strategic plan, goal, strategy, and implementation step. For opinions, this is going to be the same, essentially, unless the committee decides to focus on an area that's not within goal 3, which is really those education resources for attorneys. So it's most likely that the strategic plan, goal, the strategy, and the implementation step are going to be the same for all of these. It's really what the work is and the deadline and the prioritization that is the focus here.
Okay. All right, well, let's start then with client files, release and retention duties. That's, Guzman, she's not here. Is anybody on this committee can speak up as to what the status is, what's going on with this one, so we can plug in? Who's on here?
I'm on
Brandon?
it.
So we have, yeah.
I'm on it,
Glenn, Jen.
but I don't have much to say. We all reached out informally to practitioners in the criminal sphere that one of the big concerns was the burden this would impose on solos and people after the fact. And the couple folks I reached out to thought the opinion got it right. But I don't recall if we were going to do anything more formal, like as we did with the AI working group, like really bring in some practitioners to dive in on this. It went out for public comment once, and I think the opinion's correct, but I don't have much more to offer than that. Obviously, Hunter proposed this, right? And he's dialed into the criminal practice, and we sort of lack present expertise in that area, which was one of the challenges we're facing.
Okay. Oh, sorry.
Oh, I'll just say, I think Eleanor and Novella both provided additional contacts who have criminal experience. And I'm not sure, Brandon, I don't know if you know, did that group meet with those additional contacts or Vikita?
We provided the information, but that was it. I mean, that's the extent of what transpired. We didn't meet with the actual practitioners themselves, no. It was just about providing the information, and once we provided the information, it became that was it. Kind of got stalled at that point.
Did they have the same sense as Brandon's criminal law colleague that it's appropriate, or did it get that far?
It didn't get that far. Mine had the same as Brandon's, but it didn't. I think that's the point where it got delayed or stalled. Trying to find the nice words to use.
So it sounds like more work to do on gathering.
It is.
data.
It is. It's just
Yeah.
basically kind of making the determination of what's going to transpire now. Now that we've got the information from the criminal attorneys, what are we going to do with that particular information? How do we move forward with it? So we're kind of just like sitting there trying to make the determination of where we're going to go next.
Right. Like, are we satisfied that our sort of informal outreach is good enough, or do we need to do something more formal to make sure that the criminal bar, who is going to be most affected by this, is paying attention and has their say, and we can consider it? Or are we good with what we drafted, which we think tracks the rules and the ethical requirements? But I guess that's the big decision to make right now.
And what was just remind me, how long was the time period you all were recommending or saying had to hold files?
I'm incapable of reminding you of that, but I wish I could. It's in there somewhere.
I remember.
Wait. Oh no. Novella. I know you're not on the committee, but sounds like you were somehow involved. Do you remember?
I don't. I was gonna ask though, when we submit it for public comment, is that when the criminal bar like more widely would give the input that Brandon's suggesting, or is there a reason to like submit it to them before it goes to the public?
Theoretically, conceptually, you're 100% right. That's exact. But we have like a lot of these things go out that get very little attention the first round until it gets closer or gets finalized, and then everybody tells us all the things we wish they'd said earlier. But you're absolutely correct. That's the purpose of the public comment. So. And we could just do that.
Do we do like special outreach to public comment to try to prevent them from waiting till the last moment, or is it just like lawyers are going to procrastinate?
I'm not aware of any particular outreach to like bars or sections, which might be a really good idea.
So this was issued for public comment a long time ago. And it doesn't, what I'm hearing is there's no current proposal to make any substantive changes to it. However, at that time, we weren't as an organization as focused on targeted outreach, and I think we are much more so now. So perhaps it makes sense at the March meeting for everyone to have reread the opinion, the entire committee, and decide if the committee thinks it's accurate based on the existing law, and if so, if it makes sense to reissue it and do that targeted outreach as part of the public comment process before and then see where we are.
Okay, so this is just more of a structural question. So that's gonna go into the work plan box. Who's preparing the work plan here? Is somebody taking notes? Okay.
I am.
So, yeah, so let's put, and then so the deadline will be March meeting. And the priority, I mean, I think this one is a priority to just get it done and out. And this is one that's not, this is at the end of its life and ready to fly.
So Erica, I'm not looking at the work plan. Maybe it'd be helpful to me because I'm not looking at it. Can you just put the work plan up? Just so we can see all the elements, because I think typically if you have the dialogue, the work plan is axiomatic, meaning we have the dialogue, we make the decision, you go back, you fill it out, versus trying to fill it out as you're going, because it's just going to represent what we decide. But
Well,
I
I
don't
know, but
have
it's
the,
got- it's
I don't
gotta
ha- but I
capture
don't
the-
have the form in front of me. So let me just see. Okay, and so deadline means completion in your language, in this language?
Well, the deadline of whatever the strategic plan is, the deadline to complete that.
So
Right.
there is, I mean, I think a question here is like, this is something that can be revised, right? This is a template.
Right.
So do you
Okay.
want it to be, the deadline could be to the board, right? That's the final product. And then the deadline, this could be just next like action or something like that, as opposed to deadline. So next action here, it sounds like is March for consideration. And then thereafter, if it's voted out for public comment, the next action would be the meeting after public comment, so to speak.
Okay,
we
let
gonna
me,
Is it gonna, does it have to go to public comment again if we decide that it's fine in its current? I don't, it does
If
have to go
there's-
out for.
Sorry, Kirsty. If there's no substantive changes, it doesn't have to. I think the concern of the committee is that, one, the public comment was a really long time ago, and two, that there wasn't much, and this is a really wide reaching, there's a lot of implications tied to this opinion for criminal defense lawyers.
yes.
Okay, yeah.
Column title, 2 boards sitting as, what does RAD mean?
It's the Regulation and Discipline Committee.
Okay, which is a board, okay.
Yeah.
To me, the deadline, which should be completion. I would just think we just say what the terminal date is. In other words, based on what I heard, I would say September 30th. Based on what I just heard on on the first one.
Okay, so.
Versus trying to do every single step inside of here, I don't think
But should we have like flags on, as to what the next thing that we have to do with it is? I think it would be helpful to know kind of like what, like you said, like all of us to look at it for the next meeting should be reflected, perhaps.
I think it should be both. I think we should we should chunk it so that, we know what the interim deadlines are, which is March for and can't we just put that in the work plan? But I like the idea of having a drop dead deadline of when we expect to get this out, for publication. Right?
So
Or at least for approval.
So what y'all are talking about, even though Erica has implementation steps, which was more related to the board goals, you could literally use the step category, because what you're talking about is steps in the work process to get to the completion date. I mean, that's really what people are saying, hey, I want to see that all on one piece of paper. So the step would be come back at the March meeting, whatever you said, Erica. And then public comment, let's just say June, and then finalize whatever needs to happen between June and, if I said it, the deadline was September.
Yeah, I mean, I think we have.
So
to
those
have
would be steps. And everybody could see now the relationship is really the committee has to manage the steps along with the person the chair who develops the agenda. I mean, that's the That's how we're gonna know what we're doing in terms of the committee. You all have to manage that. It has to show up on the proper agenda, and the committee has to be in some way leading it or saying, which I think to some extent happens now, but is not as clear. Angela says, hey, everybody, you're supposed to, turn in your information for the meeting. And oftentimes we come and people didn't turn in the information. They weren't ready to prepare. I mean, so now if we agree to this, we're not just voting on a work plan, we're voting to say we're committed to everything it takes to get this done. So I think it's a more of a commitment than just this document.
Well, I'm a
Okay,
proponent of
so-
dates, right? Because I mean, I think for me personally, I work better with dates to say, okay, we're gonna get this done by this time, we're gonna get this done by this time, right? Because now here we are with an opinion regarding this criminal one that we haven't had any follow-up, and it's just kind of out there and nobody can speak to what's going on with it. So I think, I'm in agreement with that. We need to put the strategic goal as to, number one, where are we, what's going on with it, and when are we going to have it finalized? So having some concrete dates, I think, gives us something tangible to work with.
Yeah, but we have to be like forward thinking about it. I do like the, idea of like what's always have in our sight, what's our end
What's the
game for this
goal?
particular opinion,
Right.
Yeah.
Right.
So the question is, where are we putting that in this work plan, I guess? So I like the deadline column being the drop dead deadline. What's our aspiration for getting it voted out for publication, final publication? And then the interim steps are deadline, we'll put deadlines for those within, is that the middle column there that you're creating, Erica?
Yeah, so this, we have a custom color, so just ignore the navy blue and I will put it in the right splash color later. But so this would be essentially interim steps, right? So we would move these
March, yeah.
over.
Okay.
And obviously the benefit here is that it could be done sooner if at the March meeting it's determined that there's no need to issue it for public comment.
Yeah, I mean, I guess the interim step, there's a decision tree there that it might change later deadlines.
Right.
Well, okay, go ahead.
I heard September 30th from one.
Yeah, I mean, what does the working group think? Let's put in a goal there, based on Brandon.
Well, as the guy who just remembered he's on the working group, I would say the key is what we discussed at our March meeting. If there's no more to be done, we're done in the March meeting. If we do think we need to do specific outreach and we're not confident in where the opinion is, maybe September is fine.
So asterisk that September date.
Yeah, plenty of asterisks.
Well, it's a deadline, right?
Wait. Yeah, so wait, Brandon, so you're saying you could get it done sooner if not a lot of work needs to be done. Is that what I heard you say?
Honestly, it's a committee decision as to whether or not we want more outreach or whether we just take it as is and vote it out.
Yeah,
But-
and that
right.
decision will be made in
after that
March.
discussion. Yeah.
But with engagement, given the new goal, September, you're saying you could get it done by.
Well, I'm not getting the outreach done. So that is, like a state bar. I don't know what the outreach, I've never done that. So that sounds as reasonable as it could be quicker. I don't know.
Okay,
What do you
so
think,
I
Erica?
think, yeah, okay. So to me, the deadline is by this time. It doesn't mean you have to wait till September to get it done. It means don't go past that date.
Right.
So
And
I
we
don't,
can
so, I mean, and you don't need to update it. I mean, if we're talking about this next year and we got all of them done before, then that's great. But if we get them all done on the date that we said, that's also great. What's not great is what we have ourselves now, is we give ourselves date and we don't meet most of them unless
Well,
they're
that's what we-
imposed by someone else from the outside.
and that's why we'll have, okay, but yeah, we will always, this is a working document, so that, but we will always have this work plan in front of us at each meeting. So that we, we'll have all of this, in front of us.
Well, I guess, Cassidy, I'm saying something different. What I'm saying is whatever we agree to, that's what we should work to. It doesn't help us to every time keep changing the date. So let's hold ourselves to some discipline, which is why I asked Brandon, are you saying the 20th
Well-
September seems reasonable? If not, then move it to November.
No, I know, but this is a
there's
tough
no-
one. But this is a
Why?
tough one because there's some
Why?
uncertainty here that, so it's reasonable to like not be completely clear on the September deadline, because we don't know what this outreach is gonna look like. And we don't know, whether or not it'll be voted out in March, but
So let's
I'll-
put November. Let's put
Let me
November.
say
then.
something really quick. I don't think that every single one, based off of where the opinions are, we can be able to give a hardcore deadline as far as when it's going to be completed. I think that what we can do is provide a status update, because you don't have all of the committee members present to be able to speak to
Right.
that, right? Especially if we're taking a stab at this very first one. And we've been talking about this one for a little bit now. I think we put in the interim steps. And then as far as the actual deadline date for this particular one would be to be determined. And we would provide that update, that date, based off of what the committee says that they're able to get that information done.
Right, so like we can put for the March meeting, establish firm deadline.
Right.
Because we'll know better then, yeah.
We'll
but,
know
you
better then. It's hard to say today.
Yeah,
And we don't
so
want to
we
put
can-
an unrealistic deadline date, because you put something in September, I can tell you, it's not gonna be a high priority, because it's like, oh, that's in September, that's like 8 months away, right? Realistically. But I would say make March as an interim step, as a huge deadline date, to be able to say, these are the things that need to be accomplished, and this is what we need to come back with. And that puts a shorter time period for the committee to get together and come up with what is it that we're going to be able to do. Because you only got Brandon and myself on this particular committee, and we don't have much information to provide you.
So, okay, so let's, then some of these will not, well, at least this one won't, I don't think we should have a deadline, I agree, I think, but we're setting the deadline at the
Interim
March meeting.
steps, and right,
So,
deadlines on
so
interim steps.
we're gonna spend the whole year on our work plan.
We're gonna
because
spend this
just
whole
keep
meeting
coming
on this
back.
particular one.
And we're just gonna keep back because we're unwilling to commit. And I just think
Well,
it's not great.
Yeah, but you can't have unrealistic commitments, I mean, like,
If we can't get it done by November, we got a problem. Let me just say that.
Okay,
We got
but
a problem.
let's
We
move
got
on.
a real problem.
Yeah, can we move to the next one?
Yeah, let's move on to the next one, and we'll see. I'm sure some common issues will emerge as we go through this. But let's see how we can get through them. Okay, so how are we gonna do, I don't understand, I don't have the list in front of me
Yeah,
now.
Erica, I just wanted to see it because Cassidy was referring to what she was trying to fill in. I'm fine
Okay.
to see the list. I see what we're working with,
Great.
which is 3 categories primarily.
I will.
Okay,
go-
so,
Do you want me to go back to
Yes.
the log?
yeah, please. And we're getting a lot of this, we have these opinions on the agenda, and we can discuss them a little bit here, and we may not need to discuss them again later on. So we're kind of like throwing a wrench into our agenda a little bit. Okay, so it's lawyer as expert witnesses. So that's Dan, Carrie, and Brandon.
Okay,
Okay,
this is
so
a good one to use because we actually have progress to report. You have all received and reviewed in great detail the revisions to the draft. Specifically, scenario 3 has been overhauled, but Brandon and Carrie and I have met in the working group, and we love it, and I hope you love it too. But the next step, this one already went out for public comment. The next step would be, if the committee approves it, it would go again. And then it really should be relatively close to becoming final unless everybody hates what we've done. So this is one where I think if we send it out for a public comment, then it would be on that schedule, basically.
And it would, these are significant substantive changes. So would, if approved by us, it does have to go for public comment again, right?
Yeah.
And so we're planning on voting it out or not voting it out today, or voting today on it? It's on the agenda, right? Yeah. Okay, so that's easy. And that one is, there's no really, not a, well, depending on the public comment. There's not a lot of more to
Can
be done, but.
Flag a challenge here, and I think this is what is already started in 19004 and now, is that this is the committee could want to issue these today or tomorrow or 5 years ago, but because of the fact that the committee must be responsive to public comment in some way, shape, or form, that if an opinion, like for 19004, if the committee decides to issue it again, it could be that the public comment says this is good as is, and then it can be voted out at the June meeting. Or it could be that the working group or the public commenters say this is terrible, and it's going to take another year of revisions and another public comment period and so forth. And so I think that's going to be the challenge here. So for those that have gone through a second round of public comment, there's no substantive revisions. Those are easy to just say, this is done. And this is perhaps why this committee has not had a more formal work plan, is because it's so codependent on public comment that it makes it very difficult to accomplish this. So I would just, to the extent, I think having interim steps is a really great plan. And then I do think giving a deadline is also a really good plan, but perhaps just putting that deadline as being, a year from now for those where you're uncertain as to whether or not it's going to need a public comment, that may be appropriate, but I think that's where you're looking at the schedule and thinking backwards of, let's assume that we need to do another 60-day public comment on this and no more. Is that a 6-month process for this committee? Is that a 9-month process for this committee? And what is that going to look like?
Yeah, I mean, I kind of want to even break out those opinions that have never gone out for public comment, because that can be an easy deadline, to get the opinions out, those particular opinions out for public comment on X deadline, because that's entirely internal. And we can prioritize that. But are there any pending opinions that have not gone out for public comment here?
Cryptocurrency has
Who
not.
has it? Right. Yeah, there's a number of them.
And the new in-house counsel split opinion has not.
And reasonable fee has. Okay.
Yeah, those are the only two.
Okay, so so what I propose then for those is that the deadline will be to, the outside deadline will be for getting it out for public comment. Because you're right, I mean, I don't, it will be really, because we don't know what the public comments are going to be. It just kind of creates a sort of a black hole once it's sent out for public comment as to the timing in some way. But I think, so with those, for the ones that have already gone out for public comment, the interim step deadlines are the most important, because we want to continue to push them. Okay, so do we have that? We have experts, lawyers, expert witnesses, so that one is, we know what we're putting in the work plan for that one, Erica?
Yes, so it would be to issue it for a public comment essentially at this meeting, and then it would be, depending on the public comment period, I'm assuming it's going to be a 60-day, but we will learn more on that later. It would be revisit at the May meeting, essentially, looking at the timing of things.
Yeah, so that I think is like the mapping that you're describing, where after it comes back from public comment, the working group has to advise the committee how much time they think they need, or whether there's something significantly challenging that needs to be addressed, and then set a new deadline at that point for the next phase.
Yeah. Okay. So, okay, so 60, so we're 60, so for this one, it's be 60-day public comment, then we'll be back in May, and then at the May meeting, that's what you're gonna make recommendations for particular deadlines and that sort of thing.
Yeah, and like the in-house counsel public comment, the working group would be able to say, okay, the comments were good, we incorporated them, and we think that it's sufficient to go now, or we need to fix this, but here's a deadline for when we'll be ready for the committee to look at it again with public comments.
Yeah.
And some kind of a plan which includes staff, processing the public comments and doing those kind of things.
Okay, yeah, okay, so that sounds good. Okay, let's go to flat fees and termination. Wow, Brandon, you're on all of these.
I think he may have stepped away, so I can, oh,
I'm still here, sorry. Yeah, I mean, I shouldn't be on all of these, but I somehow. So we are, we've got some public comments. Erica, are we going to talk about those later, or, yeah. So we've got some public comments sort of diametrically at odds with one another, which is always exciting, that we should talk about, but we should also talk about getting some members on the drafting working group here too. So, it depends what we as the committee at large think of these comments as to how close or how far we are from completion. I will also say that the impact of arbitration advisories is slightly expanded, right? They used to be intended solely for mandatory fee arbitrators to administer arbitrations and give volunteer arbitrators guidance. And they've always been used a little more broadly than that. But I do think there's more emphasis on them now that they come from COPRAC. And so we get a lot more public input and we get a lot more disagreement that we have to sort through. That's my only report. Erica, do you have anything to add?
No, just for purposes of deadline interim steps, and I see that Raquel has her hand up. I would just say that there's a thought that this would come to the board at March with recommendations incorporating or not incorporating the public comment.
Right.
Wait, say that again? Sorry.
So the public comment period ended on this about 2 weeks ago. And so Brandon, as a working group of one, has reviewed those public comments, but I think he's hoping for more working group members to join. And then the thought would be that the opinion would be turned around for the committee at the March meeting.
Okay.
Either with substantive changes that would require a third public comment period, or no changes, and it would be voted out to the Board of Trustees at the March meeting of this committee.
Okay. Okay, and so that's one we'll be discussing later too, if we get to it. Okay, so let's do conversion clauses and contingency fee agreements.
Cassidy, before you move on.
Oh, sorry, Raquel, sorry about that. Forgot.
I would volunteer Brandon to join your committee. And I do think you probably need some more people. Erica, as I hear us talking, would like to have your thought on the positive benefit of having the staff opinion drafter, because I realize as we're talking and we're thinking about opinions, maybe we're not factoring that in, that we are going to have more another person who in some way we could give them a lot of the work that is the part that we haven't been so effective with doing. So I'm just curious, your thought about how that's going to expedite it, or, and certainly we'll probably have to get used to it because, people are used to writing. So when you're having someone else write, it ends up being more helpful, but to get there is not always easy for people.
Sure. So I will answer that. And then I'm going to also say that effective Monday, I'm going to need to defer to Kathy on this because it's the office's staff that typically does this with the director's review of that work, essentially, or the managing attorney. So at this stage of an opinion, this one's been out for 2 public comments. I think what makes sense is for staff to incorporate the public comments that the working group agrees with. So we'll get into it in more detail, but there's the California Lawyers Association gave us a 22 points of edits, and many of those are non-substantive. And so the bigger picture questions are whether or not the opinion should recommend milestones versus recommending basically tracking your hours and flat fees. And that's something that I believe the working group will have to grapple with and decide the direction that they want to take. There's a fee arbitrator who provided public comment that basically disagrees with the approach that was taken, and CLA didn't indicate any disagreement with the current approach. And so that's going to be for the working group to decide and make a recommendation onto the committee. So my personal recommendation is that staff would implement the recommendations of the working group. And so what that would likely mean is that staff would sit in on a meeting of the working group where the working group has reviewed this in advance and gives direction. This could also happen by email, but it just may be more effective in a meeting. And then staff would make those edits, turn it back to the working group, assuming they're approved, then it would move forward back to the full committee at the March meeting, as an example. So where I do see the value of staff is front end, so issues outlines, and really at the very end, because all of the other, I think staff could be a part of that and be a note taker or even draft opinions as appropriate. But I really think, the committee exists for a reason. These aren't staff. It's not the staff of professional responsibility and conduct that sends these to the board. And so I think that the thought continues to be that COPRAC will be really involved and invested in this. But as far as drafting, I think for now it makes sense at those 2 ends. And then we can see how that's working for the committee. So far at the end of it, working on implementing public comments seems to be going pretty well, but that's relatively new. And then kind of working its way farther and farther into the beginning stage, the middle stage, I think would be the best approach.
Thank you.
Do other, I'm just so curious about how other state bar ethics committees run their, rollout of ethics opinions. Do they typically have the same kind of public comment, board approval type process, or is this, did you know, Erica?
I don't believe they have this. Well, some do. Florida does, for example. But I'm not sure that there's a true consensus. We could look into that. I'm not sure. We can't without board action, which I said earlier that I wouldn't predict the board. I would predict here that they would like to continue public comment in this space. So I don't think it's likely that the committee would move away from getting public comment on formal opinions.
No, and that's not what I'm suggesting at all. I just, everybody criticizes us for being so slow in getting opinions out and, in comparison to other state bar committees. And I've never thought about the fact that our process is a little bit more rigorous than maybe some other committees. So that, not that, whatever, we should be more efficient as well, but it's part of the delay. I don't call it delay, but it's a process that we adhere to. That takes time. Okay, that's just, my extraneous commentary and random thought. Okay, let's go to, where are we? Conversion clauses. Brandon or Eleanor? Is Eleanor
But
here?
by the way, I'm also happy to be on the to join that last opinion committee as well.
So
flat
conversion
fees.
clauses is very excited to be becoming one of the oldest of all opinions. Topeka did an excellent revision and trying to find common ground. We all view the question was, how far is this opinion going to go? I think everybody, every time this has come to the full committee, has had a consensus that there is public protection value to be had from an opinion like this, but how far are we going before certain members are uncomfortable or think it has overstated the case? So Deepika did an excellent revision that is now with Eleanor for her comment. I would assume we can have something for the next full meeting for evaluation by the full committee, take the temperature of the committee and see where we're at. But you know, Eleanor hasn't had a chance to dig in yet. And so I want to caveat that, because if she has significant reservations about where we're at, maybe it needs to sit with the working group another month. I'm not sure.
Brandon, can I ask a question? Based on the revisions, would it require another public comment period?
That is very interesting. I don't think so. It would be returning, I believe, and we can fly spec this more carefully. If the current revisions are acceptable to everybody, I think it's returning very closely to the version that went out for the very first round of public comment long ago. What is that? 2 years ago, 3 years ago. So it probably wouldn't need. I mean, well, let me ask you that. If the first version went out for public comment and it was we've got public comment, we did a revision that got a new round of public comment, and let's say we return to the first version, does it need to go out for public comment? Because it would be significant changes since the last round.
Yeah,
but it will be in line with the first round.
I think it does, but we can confirm. I'll confirm that behind the scenes, but I'm pretty sure it does.
Okay. Well, it is what it is. There's
Right.
probably no reason to rush something that's been in the pipeline for 30 years.
So Brandon is the lead on 01, 03.
I don't think I'm the lead anymore. I think I'm the steward. I think it's going to be
Oh.
down to Deepika and
Oh,
Eleanor.
Topeka. Okay.
It's not a
Yeah.
Because I
category.
realized that some of these we don't have who's the lead. We should
I believe
probably
Topeka
do
is the
that.
lead on this. I'll
Okay.
update that now.
And then on 03 is Brandon still.
Only until other people join. I know you all want to be on this thing.
I think
You had 2 joiners.
Yeah.
Nima, actually, yeah.
Excellent, excellent, excellent.
But for now, you're the lead. Is that right?
Yeah.
Because part of the work plan is being clear on who's leading.
And
And
I
then
believe,
lawyer, the number 1 is who?
I believe that's Dan at this stage.
Sure.
Yes.
Where's Dan? Okay, Dan, sure.
Okay, are we moving on? Okay, so ethics of in-house counsel. This one is me. Nima did some great revisions to this draft. It's not ready to be voted out. I want to take basically a straw poll on one concept or one kind of significant change to it that we can get to. But then the goal will be to vote it out for public comment at the March meeting. Because it's basically ready. There's just one kind of big change that I want to make to it. That is in line with where it was headed anyway, which is that the rule 1.8.1 does apply and you need to comply with it if you're an in-house lawyer. So so that's the status there. Nima, and Dan, do you have any, and Raquel, do you have any input or comments?
Yeah, I mean, my take on it is that I think we kind of hover around the right approach, which is I think that there's sort of a tension between kind of just saying it explicitly and basically, acknowledging the reality that in-house counsel probably in a lot of situations don't really think about this. But my reaction was like, I think that we can still say that it applies, but there are, like it's not a huge lift to require compliance, but we can, but on the same token, like, you know, there are considerations if you're thinking about not complying, like what you should think about. And although we don't and can't recommend that.
Right, so that's the struggle, is like, you know, how clear are we gonna be on our guidance here? Because, well, anyway, we can get, I have an idea, I think, that I wanna float, just on the structure of the opinion that we can discuss when we discuss the opinion. But it needs a little bit more work, as far as the drafting, and I don't think we can be wordsmithing it, today, but I do think it'll be ready to be voted out on at the March meeting.
Agree.
Okay, so cryptocurrency. So okay, so you got that, Erica. Cryptocurrency. I think Bill and
So
sorry,
yeah,
is
Eleanor's the
Ellen?
lead. Yeah, Bill's on it. We had a meeting. I think, Bill, you missed the meeting, but I'll just say, and Nima can say if I'm off track. But loosely, we'll be ready to share where we are now in March. That was our loose frame.
Yeah, we totally agree. I think the opinion's in great shape. We were kind of working through some structural things and a little bit of a different approach, broadening that beyond just the term cryptocurrency to digital assets more generally, which, you know, I think what we're seeing with this new administration is a significant adoption or warming to digital assets. And so I would not be surprised to see more of this stuff become prevalent and perhaps commonplace in the, you know, even in the legal profession in the next few years. So trying to make it as broad as possible, I think is probably as broad and as narrow as possible, if that makes sense.
Yeah. And so are we discussing this opinion today, or is this just?
No, May. Well,
Oh, May,
March.
right.
I'm sorry, March. March is when
Okay.
we'll discuss it.
And well, yeah, and then maybe we'll have even more information about the administration's treatment of it's just a moving target, yes. Or
It
a runaway
sounds good.
train.
It sounds good. It's unregulated. We can make lots of money. Yeah, let's do it.
Yeah.
And like we don't need to hear much more. I think we got the
I
point
know.
here.
I mean, I have my opinions about just, yeah, anyway. So I'm glad we're not talking about it today because it's a rabbit hole. Okay, so what do we have? Can we scroll down?
Yes.
Okay, oh, that's me. Is this still up that in the opinions? Okay, so attorney as expert witness and handling retainers and fees. So this is one that it's in the baby stage. It was an outline that was done by me 2 years ago. And nothing's been done on it. So I think this is one that can be moved to, is it something we want to pursue or not? And you know, I don't have any, well, it's one yeah, this one should be moved to, like, it should compete with the new topics, I think, because it's so, there's not a lot of work that has already been put into it. So it's, you know, I'm comfortable with putting this on a list of opinions and prioritizing them, and it could be, you know, lower on the list, frankly.
Cassidy, I'll just
Depending-
flag here, what was discussed at the December meeting as a possibility was converting this into an opinion that talks about Rule 1.15 and attorney adjacent services. So serving as an expert witness, we did receive that request about forfeiture of assets from district attorneys and whether or not those are things that have to comply with 1.15.
So what goes into the trust account? Yeah.
Essentially what goes into the trust account, if anything, and that's what this opinion is really about as it relates to expert witnesses, is what the trust account obligations are for these funds as to whether they need to go in or not. And I think this opinion is more important. This topic is more important now and maybe needs to be expanded because of CTAP and the fact that attorneys have to report what is the at least the balance of their trust account, and there's going to eventually be, you know, compliance reviews and audits and so forth. And so having clearer guidance on what must go in under 1.15 and what does not go in under 1.15, I do think is something that licensees are interested in knowing. It's a challenge to figure out who to address in that opinion, but it's just another opinion topic that came in that we talked about in December.
But so so this actually, I think, is a good question should this be an opinion, or can we, I think if we're talking about CTAP and everything having to do with trust accounts and all of your, you know, obligations and handling, you know, with fees and distributions from your trust account and dealing with the new CTAP reporting requirements and, you know, your duties under the new 1.15. And then, you know, and then this particular topic when you're not actually acting as an attorney, and, you know, what goes into the trust account at all, could be like the AI guidance, you know, in the sense that we're providing guidance on, you know, these new rules that it's not necessarily an opinion. And I guess my question is there is a lot of guidance from CTAP, you know, the FAQs and all of that. Would something like that be well, it sounds like it is necessary. So anyway, I'm looking for input on that. I think it is probably important to address that. I think an opinion is going to take too long. I like the idea of doing more of a guidance like the AI guidance. I'm opening it up to the floor to, you know, what do you guys think about that? Nobody?
Well, Erica, based on what you said, what do you think is required?
So there's no, just to speak to the CTAP guidance, there's no advice, because it is advice, as to what must go into the trust account or not, depending upon what the lawyer is doing. I mean, there's clear-cut issues, the attorney-client relationship, funds go into the trust account. And there's less clear answers as well. Associated with this also is who has those 1.15 responsibilities. So, you know, for those who have to do CTAP compliance on this call, that's the threshold question, is do you or do you not have those responsibilities? And several attorneys don't understand what that is and whether or not it applies to them or not, especially subordinate lawyers. So like at a large firm who do directly deal with the client, but do not, you know, the funds go directly to a completely different part of the firm. They would never touch a check, never touch money, any of those types of things, never touch a wire. Check may be obsolete.
But if they're talking to so this is kind of discussed in the FAQs and the guidance on that, you know, this particular topic. And so if we're going to be opining on what that means, we're kind of interpreting the guidance, right? And and I can't remember, I don't have it in front of me, but it basically says everybody's required, the threshold question is everybody's required to report unless you're a government lawyer, a judge. There's like those 3 criteria. And then if I mean, basically a subordinate lawyer who has no communication to a client, like about a settlement or something like that, you know, like, so, I mean, it's pretty broad. Everybody is required to report for the most part. But you know, beyond that, so we're interpreting that, you know, if we were to give an opinion on that, we'd be interpreting that question, and the CTAP guidance isn't supposed to go beyond that, you know, beyond what they've already explained. Because that's what I advise about that all the time, about, in fact, I'm getting the questions now because of the reporting requirement, so I have to like refresh my recollection of what I advised last year about all of this, but, yeah, I mean, is this something for an opinion, or is it something that there's all this other guidance out there that we would be stepping on their toes, I guess is what I'm kind of trying to figure out here. Like what?
Oh, I'll just say from the ethics hotline perspective, that the feedback that they receive is that the guidance is not clear and that there's a big gap in the guidance. And I think that
And that's where we come in, but so we basically say the guidance isn't clear and here's the clarity.
I think hypothetical scenarios could be very helpful here. So for example, going back to the topic, an attorney is an expert witness. Do they have to put funds in the trust account or not? And then if it's not, then for that portion of their practice or work, then it would be no CTAP compliance for that. If they're solely an expert witness at this stage of their career, then they would not have 1.15 responsibilities. I just think that this question is coming up more and more because of CTAP. So
yeah,
whether it needs to be about CTAP itself or whether it's about like who has 1.15 responsibilities and when funds do or don't need to go into the trust account, I think that's an area anecdotally that we have received, people are interested in.
okay.
I think we could
Okay, so-
provide good guidance on it though, because we do have some, I mean, the expert witness question, which comes up in the other opinion that we're writing about expert witnesses, which would not be the practice of law. Also, mediation is not the practice of law. People do those through their firms. So we could give opinions about those.
In one opinion.
I think so.
Okay,
mean,
so let's.
The idea would be that if it's not the practice of law, then you wouldn't have to put it in the trust account, my thinking.
Yeah, I mean, that would be my ultimate opinion too.
But you could.
Right, but then the other part, yeah, but well, that's a good question. I mean,
I
because
wouldn't.
right, because then you're assuming a duty, then it all applies, so.
But it's
okay.
good guidance, because I know that at my own firm, when we get expert fees, we do put them in.
Well, so, right, but so like at my own firm, we have California, the 1.15, there's restrictions about, whether or not you have to put it in a California, you have to keep it in a California bank versus a out of state bank. And I think, you can, if you're an expert, you can disregard that, right? You can put it in your, the trust account in your firm's main bank, which is kind of my personal issue.
Yeah.
Okay.
Also, I think the guidance could be also very useful for the public because you just kind of have to be consistent. And with guidance, more people would be consistent. And I think the answer for both expert witness work and mediations would be you don't have to.
Is there any other category besides those two?
I mean, you could be a business consultant, any non-legal stuff you do.
Right, like a real estate agent or do they have, well, whatever. Okay. So, but then the other piece of this is who is required to comply with 1.15, and so it's when you're doing non-legal type work or legal adjacent type work like expert mediations, but also if you're let's say you're at a large firm, and so those are more the reporting requirements, right?
Yeah, but I think that could be a place where, like Erica pointed out, people have these questions. So the answer seems sort of simple. If you're not practicing law, if you are a lawyer, but your activities are not the practice of law, then you wouldn't.
Right, but you wouldn't have to comply with 1.15, and then you wouldn't have the reporting requirement. Yeah.
Yeah. I mean, all it requires is kind of a simple, common sense, consistent guidance.
Okay. Okay, well then let's put this for an opinion, and we want to put it on the work plan.
And we need you need some new members because you have Joel who's no longer with the committee.
I'll volunteer for this one. I think there's overlap from what I was doing on the other one.
Yeah.
Okay.
And I don't know if Brandon wants to stay on or not. Brandon, are you still here?
I am, and I think I should not stay on here.
You're on plenty, it's okay.
I bring no particular expertise to this topic, so if someone wants to.
Well, if
erase-
that's
Yeah, I
our
think we
standard,
need-
then we're really in trouble.
Oh yeah, then it's gonna be rough.
Yeah, I think we need one more. But we can, well, is any other volunteers?
I would, but I'm biased because I am an expert, so I don't think I would be appropriate in helping you out in this one.
Same.
Okay,
I don't think so either, because I'm an expert.
well, I'm an expert
Well-
too.
Right, wouldn't that be, wouldn't
We're all
that be
experts
helpful?
here.
Yeah, wouldn't that be,
mean-
why is it a problem if you're if you
I
have
think
some particular
Oh,
experience?
you can have you can
You
be
have a bias.
guided by your personal desires, not to have, and I'm fully admitting that. But it also, we bring to the table that particular
Anyway.
experience.
Yeah,
Right.
because everything
I'll
we
do it,
do
Casey.
affects lawyers and we're lawyers, so that's true.
Exactly, yeah, I mean.
That's
So
fine,
I
Casey, I'll
think-
do it.
You know, Raquel, someone may disagree with
Right.
how the funds are managed. In other words,
I
as an
agree.
expert, the group may say, well, it should go in a trust account. I would say, no, it doesn't. But, so I don't want to be involved in that because I have my own personal view on, and I don't think I could be biased or unbiased in that.
Okay. So for the work plan, then we have to set some realistic deadlines.
So this would be a good one, I think, to work with staff on at some level. Because if it's going to be a pick list of different types of practice adjacent or attorney adjacent spaces, so mediation, expert witnesses, and so forth, I think this could be an area where they could hear from your perspective where things should go and do some research and come back to the working group. If that's the case, I would suggest and because this is going to be essentially a new opinion at this point, I would suggest no sooner than May. I don't think March is realistic. I'll just say that. I think our meeting is March 7th. It's very early in March. And so I would suggest the May meeting as a goal for an initial draft.
Oh, so, okay, what you're saying is, so staff would take the kind of, the first step in preparing an outline of some kind to just define the scope,
I think we could outline it right like we just did with the points we mentioned, and then the staff would fill in the research on the items.
Okay.
Yeah, especially if this is going to follow kind of the practical guidance format, like the AI guidance was. I mean, that was kind of the approach there, as we listened to the drafting team and put something together, and they reviewed it and tweaked it and so forth. So I think that's a good approach here. If it's going to be more of a, what about this scenario? Like, what about this type? And with kind of an overview of the landscape, and then doing that, I think it could be, I'm not sure you're going to need to go into such robust hypotheticals for each example, but I guess we'll see as the committee works on it, or as the drafting team works on it. So what I would recommend is that staff participates in the work in a working group meeting on this to kind of get on the same page, and then staff could work on it.
That sounds good.
So
Okay.
Erica, based on what you're saying, really, this is going to become something different than it's showing up on this log. And I'm saying that to the extent to say, whatever public comment is really irrelevant.
It could be, yeah. So I think they should certainly look at the public comment, because I think it touches on a lot of the same issues that were raised, but I do think we're talking about it being more than just the expert witness topic.
Right. And so in that case, so how it relates to public comment is we're not talking about when is the second public comment. In some ways, and it's going to be new. It's going to even be a first public comment. That was my point.
What I would actually recommend here is that this is, if the committee decides to not pursue this, that it's a new, it sounds to me like this is a much different, it's not the same opinion at all. And so it would essentially be that this is eliminated and it's a new topic is what I think is being proposed here. And the committee could look at, like we've discussed, the request for an opinion from the district attorneys and see if that's something that fits in there or doesn't. And that could be part of the May conversation.
Can we put, I don't think we're gonna have a draft ready by May of an opinion, a full opinion. We'll just be realistic there. Let's put June in the work plan as the opinion, having as the deadline to have a draft of the opinion. And that'll give the working group more time to flesh it out and draft it. Does that sound good, Dan and Vikita?
Yeah.
Yes.
If you're looking at
Okay.
the comments, does that somewhat,
Say that again?
if you're looking at the comments and what's shared on your screen, does that actually accurately capture what's happening here?
Yes.
Yeah.
And then I'll create a new topic as we move down the list.
Okay, let's take, Nima wants to take, well, let's take this, let's take a break. Can we take a lunch break now and come back? Since we're at 12:15 and,
Yes.
I think we're a little, tired. And then, so what time should we come back at 12:45? I forget how long our lunch is usually.
It really depends, typically half an hour to an hour, depending on workload and individual committee members' needs.
So we had a hour. One of the challenges by changing our lunch is that people put their schedule around when we say we're gonna have a break. So I don't know about if Carrie was knowing, but I know Carrie was out. Eleanor, I think, is out. So that's the only thing is sometimes we have an agenda and then we make a plan around it. So.
I have a lunch meeting, so I prefer an hour, so if we can.
Are you okay, Bill? Because I think we had it scheduled at 12:30, right? So, Bill, are you okay taking it now to 1:15?
Yeah, I'm totally fine with that, yeah.
Okay, let's do that. I mean, we're about 10 minutes away anyway. So we'll take a lunch break now and come back at 1:20. Where am I?
Yeah,
More or
1:20.
less, yeah, 1:20. Okay. See you then.
Okay. All right. Bye, guys.
Yeah.
Okay. So let's finish the green portion of the opinion log and then hopefully, because Dan has to leave at 2, and so we want to push up on the agenda the expert witness opinion so that we can get that one covered before Dan leaves at 2. Is that okay? Okay, so we did attorney as expert witness. Oh, sorry. Wait, let's put it up.
no, I'm sharing now. I apologize.
No, it's okay. Okay, ethics of in-house counsel is Emil's not, is anybody on this? Vikita and Carrie, you guys are on this, right? Are here?
Yeah.
Can one of you just give us a update on where that opinion is?
Yeah, we worked on it extensively and we just missed the deadline to get it on the agenda by a few hours due to my delay. So we will be submitting it for the next agenda to go over it, but we've made great progress on it.
And it wasn't to Carrie's delay, it was to our delay. So let me clarify that.
Mostly mine.
No, it wasn't.
Okay, that's okay. So we will have a new draft for the March meeting to hopefully vote out for another round of public comment.
Correct.
Is that okay?
Yeah.
Okay, good.
So it will be the first round for this one.
Oh, yeah.
Carrie and Vikita, do you think it'll be ready to vote out at that? I mean, not knowing what the committee would think, but do you think it'll be in vote out order?
Yes.
Great.
Cool. Okay, determination of reasonable fees. That's the arbitration advisory, right?
Yes, and I can give an update on that one. So it is currently a working group of one, which is Emil, in following the concept of when the working group has termed out that staff is mostly taking these on. So the public comment was incorporated. I got it to Emil too late for it to be on this agenda, so that is on. I'll also take the blame for one, and that one's me. And so, but it will certainly be on the March meeting, and I don't think there's anything in it that is substantive enough to require an additional public comment period. Frankly, it was just clarifying the fact that that opinion, the role of that opinion, because as if you may recall, Elizabeth Bradley, who's a former committee member, was incorporating the Shepard-Mullen decision basically into this opinion. And then when we did that, there was also an addition of the, I've been mispronounced, of the Peck opinion as well. And so where that had been placed made it a little bit unclear of the role of this opinion vis-a-vis the other opinion that the committee voted out and was republished at the end of 2024 about when there is no fee agreement.
Okay. Okay, so the next one are the comments to the rules regarding judicial threats. This one should be voted up today, I think. So that's that. Those are just the comments. But we do those do have to go out for public comment, right? Because it's just like a rule revision, right? Okay. But do they go to the board first?
There's some flexibility there because of the timing of the board meetings. I think it does make sense to it wouldn't be it's too late to get it on the February board meeting essentially, which would mean that they would be sitting with the committee until May. And so because of that, it probably makes sense to get the public comments at this stage, recognizing it will have to go back out for public comment at the Board of Trustees level. However, if there already were public comments, perhaps they can make it a shorter public comment period at that stage, or there will be changes that warrant incorporation and so forth.
Okay. Okay, good. So hopefully we can get that done today. And then consideration of abortion access, that's Brandon. Yeah. I don't even know, was there ever an opinion drafted or anything? Anyway, Brandon, is he around?
Yeah, I can give an update on this one actually. So this is on hold while a bill is drafted. That bill, there is a draft bill now that is going to likely be introduced in the coming weeks by Assemblymember Zabor. And once there is a bill number, that will be circulated to the committee, and then the committee can decide if that moots the need for there to be a co-prac opinion in this space if the bill is adopted. And then just for what it's worth, my understanding is that LACPA is also the Professional Responsibility and Ethics Committee is also exploring an opinion on this very same topic. And PREC is also in communication with the organizations that are sponsoring the bill.
Okay.
So this could come off basically. Yeah. But I'd suggest leaving it on just as a placeholder on this log. I'm not sure it needs to be in the work plan.
Okay. Okay, so that's the last of the pending opinions, right? The orange, what does the orange mean again?
No problem. So the green, there's one more green, and that's just the one that you just decided to add earlier in this meeting. It's just the new opinion number for it. Those in the whatever color this is, the orangish yellowish, are those that at some point someone was interested in doing an opinion on. Most of those individuals are no longer, all but Cassidy are no longer on the committee. And so the question is if the committee has any interest in taking these up, leaving them here, or doing something else.
Okay, so we'll revisit those after we do 20-0001 or whatever it is, or yeah, no, whatever. The one that Dan is leading, sorry, I don't have the number in front of me. But it's on our agenda as item 4.3. So with that, I will turn it over to Dan.
Sure, thanks. Background for those who weren't on the committee when this went through. It's been around for a while. Scenario 3 previously said that if you are an expert and you're a lawyer at a law firm, and your law firm is representing a client, it would not be a conflict for you to be an expert in a matter that was somehow adverse to that client. We went around and around for a long time in different meetings and different drafts about that issue because it seemed to many of us not to make a ton of sense. And we sort of ended up at a place where we thought that we would go back and redraft it with an eye toward the types of rules that the lawyer would have to give consideration to, even though serving as an expert, because they're in the law firm. So this new analysis of scenario 3 walks through the rules that might be implicated, even though being an expert is not the practice of law. And the cases cited in the other sections and also revisited here draw this distinction and say, well, if expert status is not the practice of law, then doing it, shouldn't really implicate most of these rules. But then scenario 3 has this hybrid identity problem where you're at the law firm as a lawyer and serving as an expert. So it doesn't really matter that much that, or it doesn't resolve the problem to say that being an expert is not the practice of law, because you still have these other considerations just by being a partner at the firm. So the new analysis in scenario 3 walks through the rules that could be implicated by that, including non-rules, sort of duty of loyalty and just general fiduciary duties, and doesn't give a really bright line answer that you could never do this, because there are circumstances where possibly you might. I think it's a very unlikely situation that it could ever be okay. And in multiple different iterations of these drafts, we kind of sort of polled COPRAC people, and many have said they wouldn't do it. And I think, although we all recognize that conceivably it's possible without violating the rules, we just wanted to highlight how difficult this would be to navigate if you were doing both of these things. So that's a different approach to scenario 3. And it goes through the rules that, we think would be implicated just because you have these two identities, not just as a lawyer, but as a partner in the business that is potentially adverse to the expert testimony. And so we didn't take it as a completion of the answer that being an expert is not the practice of law, because you have these other identities. So for example, if you are a lawyer in the firm and you have access to financial information, you might have 1.6 issues, because you're probably seeing how much the client pays in fees. You might be seeing what they haven't paid. Those are obviously confidential. So there are ways that being a lawyer and a law partner intersect with these roles, even though the expert work is not the practice of law. So that's the approach. And we walked through these, and as you can see, we came to the conclusion, well, there's not really a sort of a bright line conclusion. It just says these are the rules that would be potentially implicated by this. And We did not say it was impossible to do this, because it's not. But we wanted to make it clear that if you were going to do this and it was technically within some of the rules, that there are other rules and other considerations that you should think about, which at least to the working group kind of leads us to a much more common sense intuitive place, which is, why would you ever do this? So that's where this draft is.
Okay, so is there any, who else is on the working group?
Harry and Brandon.
Carrie, do you have anything to add on the changes?
No, there's, I could not put it any better than Dan. But we did spend a lot of time going through this, and I think we all liked how it came out.
Okay, well, I haven't had a chance to review it in detail, so I will trust Dan's revisions, but that's why, does anybody else have any comments? Because we're planning on voting this out, right?
This would be
Yeah.
to send it out for public comment on the second time. Yeah, it's
Yeah.
material than it was. Novella has her hand up.
Yeah, I
Oh,
was
sorry.
also wondering if people would, like, if attorneys would ever do this. So it's helpful to hear the feedback that, like, probably most people wouldn't, but I think if it were more of a gray area of whether or not people would do it, it might help to, like, flesh out the hypo so people could understand why it would be so bad. But my initial thought was like, this seems like a bad idea.
Yeah, that's the issue that we took up when we did this revision, because I mean, the reason people would do it is money, obviously, but also because you don't, the cases say, and a lot of these sort of authorities provide that being an expert is not the practice of law. And so you wouldn't think, in some cases that analyze this issue that are cited here, come up with the conclusion that therefore you don't have to worry about these things. And it just doesn't make a ton of sense, because there are rules that apply to the lawyer regardless of what they're doing. So the hypo is actually relatively straightforward. The facts of this scenario 3 are pretty basic, except the rules would not prohibit it, technically.
I think, sorry.
Oh.
Okay. I think, if we wanted to tease it out more, we could, I can't see the entire thing right now, but we could think about talking about just staff at a law firm too being exposed. That could be like a 1-sentence add-on. Because I think it is broader than just the duties a lawyer has. If you're in a large law firm and you've got people who are exposed, you have a duty to protect the confidential information. And if they have it, it could create a conflict. Just having it can create the conflict.
Right.
So
that's a good point.
That would be, I think, my only comment on this. I'm very comfortable with it. I like it. I like how it's come along. I think I would vote for it as is, but that would be the only kind of suggested potential addition in my view.
Okay, I like that. We can do that. I do think it's important, because that kind of gets to the issue, which is independent of what the individual firm, lawyers, or the expert are doing, the firm has this information. It's in the ecosystem. And if the person who's serving as an expert comes into contact with it, which they likely would do, any business aspect of the partnership would be within their possible purview, that creates a real problem.
Yeah, or if their staff does, and the staff is working on a matter where there would be a conflict, the confidential information could be materially used. There are cases that say possession and exposure to material information can create the conflict. absent an attorney-client relationship. So I think that gets into a tricky issue that might be worth highlighting for people.
I mean, the other practical concern, maybe, and this is what sort of maybe Novella is asking too, is the implication of this is if you're an expert, this is a guidepost for how to get you disqualified.
Right.
Right. And it's not a really responsible thing to do as an expert if you have this huge vulnerability to disqualification.
Yeah,
So
or
that-
to due to your, colleagues, clients as well, because it could work both ways potentially.
Right. And I mean, if you were an opposing party and you saw this, you would of course try to disqualify them based on this. No question
You
about it.
might.
Okay, well, then we need to take some discovery on this. Let's find out what he knew or her.
Right.
You might. I would.
I think there was some discussion earlier today about like, would it be any different if you were engaged in a business relationship or there was consulting? And I think most firms that do those types of things are probably treating the conflicts rules similarly or creating different ecosystems and walls, or, they're doing something to segregate.
They certainly should be. I mean, if mediation is another one, or possibly some aspects of lobbying, or like you said, consulting that aren't the practice of law or might not be, it doesn't take away the core of the problem, which is the confidential information in the ecosystem.
So if
And-
everything's walled and it's all protected and all that's in place, then you can probably do it. May not be
Right.
the smartest thing to do, but
And that's why we didn't go so far as to say, like, no, you can't, because you could theoretically
Right.
do this with screening and other things. But practically speaking, we're just pointing to how difficult that would be.
Right.
And why? Why do it?
Yeah, I partly wondered if, I see the economic motivation, so I was wondering if people who wanted to do it for that reason were talking themselves into it by saying like, oh, well, this matter isn't directly adverse, or so that I was wondering if filling in that part of it would help people see that like, oh, maybe not. But I think it's already built into the hypo that it will be adverse. So it's like how much do you want to dig in on that versus just stating the bottom line?
Yeah, and I think the other scenarios kind of go into the components of the ways that expert work can be adverse to stuff. So that seemed more or less covered. It is relevant because you could, if the result is odd, which this previously was, at least to some of us, you could ask, why is this a relevant hypothetical? But I do think that it is because the cases weirdly suggest, they correctly suggest that being an expert is not the practice of law. But extrapolating from that, some of the cases go into gray territory and suggest that therefore the rules don't apply to you. And there's some loose language in the cases that say, if you have the expert hat on, then you don't have to worry about the rules. And that's, of course, not true in these sort of hypos.
you have imputed duties. You still have a duty of loyalty. You still have those duties don't go away just because you're wearing your expert hat.
Isn't it analogous to the dual professions analysis where you're, if it's a law related service, it's the duties and the rules do apply. So wouldn't that apply here?
Yeah. It kind of, except that what we're pointing to here, well, that's why it's not prohibited, like strictly prohibited, right? So yes, if you're an expert and other things being equal, then no, the rules wouldn't strictly apply. But it's the fact that you're also the lawyer and that you're at the firm and there's a possible adverse situation. So that's what this now points to, which is, as Eleanor just said, these are the things that you're exposed to as a lawyer at the firm, whatever hat you have on, which are going to impact that hat wearing.
Yeah. Yeah, so it's just kind of along the lines is you never take off your hat. So you're gonna, you're always gonna be held to the standard as a lawyer, even if you're also serving as an expert.
Well, I mean, if you're a lawyer and you serve as an expert and a mediator, both of which are not the practice of law, and you don't do anything else, then these issues wouldn't come up.
I guess I came in late here. How would that apply here if say rule 1.6 or there's a conflict? Seems like that would come up in a conflicts check. If there was a conflict, you wouldn't even be acting as an expert in the case. I guess I'm confused by we're having a discussion about confidential client information. And I'm sure I missed it. I don't see how that even applies here. Because neither party, if you're an expert, well, the way I do it, they're not my client. There is no attorney-client relationship between me and the lawyer or me and the lawyer's client.
Right, but if you're first relationship with the client, it's imputed to you.
Right.
Yeah, but if that were the case, I would have taken the case because there would have been a conflict if that were the case.
It's not a conflict. That's the whole point of this opinion, is that under a strict reading of the rules, it's actually not a conflict because it's not the practice of law. So you're not being directly adverse to your client in a 1.7 analysis. But that's the point, is like, even if you can do it under a strict reading of the rules, there are other duties that you have that would still render it unethical for you to do it. But I realize it's hard for you to even wrap your mind around this scenario because you would never imagine doing something like this. But I think others maybe are not as yeah.
That's the synthesis, Bill. I think also, so for example, in your practice, if you, and so the way this was previously drafted, it was based like, oh, it's not a conflict under 1.7 and these reasons because of what you just described. So how would it ever come up?
Right.
And that's where we got to this revision because multiple of us were just like, yeah, but that's not the end of the inquiry because the hypo says you're a partner at the firm. So in your practice, it's the equivalent of, Bill, it's like you've been practicing law in one part, you're being an expert in another, which many of us do, but against the same people.
Got it. Okay. I didn't have the hypo in front of me, so that's where my confusion came in. I get it. No, I get it.
And the history was that the analysis, there's a reason the analysis does that is because the cases do what you just did, which is, why would this be an issue? You're not my client. I'm not practicing law. What are we talking about here? So that's the evolution.
Got it. Okay. Appreciate it. Thank you.
Okay, so do we want to vote this out, or did you want to, I think, was there something else you wanted to add to this?
I would add Eleanor's comment. Yeah, and she suggested, and Erica has her hand up. Yeah, so we could add just right now the reference to the more likely scenario where staff has access to confidential information.
Dan, that was all I was going to say, is I don't want this to have to go out again just for that addition. So if that's something that could be done now, I think that would be, or in March if it needs more time than that. But I would hate for it to go out for public comment and just need that.
I think we could do it here just on what's on the screen. A threshold issue is whether the expert or staff at the law firm has obtained confidential information about the client. Eleanor, how do you feel about that? It was your suggestion. And I mean, in the next paragraph, lawyers or staff at the law firm might see or learn.
I'm not sure I like the word threshold. Significant. Can we go with significant instead?
Sure. First paragraph.
Yeah, line 249, Angela.
Eleanor, what's the distinction in your mind? Which is a higher
Threshold is higher. You've got to hear it before you move on.
Okay.
I'm not sure it's determinative.
So this is simply saying
It's
be aware.
It's an important
Just
factor
be aware.
to consider. It's another important factor to consider.
Yeah. Okay.
Not necessarily the primary one or in sequence, the first one.
Right. The sequence is another.
Okay. Do you feel like those capture the thought, Eleanor, with the addition of staff and those two things? Because I think that is the most likely way the information would be out there.
Yeah, I do. I mean, yeah, I don't think we need to wordsmith it anymore. We're gonna take, any change to it would be minimal down the road, so let's get the comments.
Okay, let's vote it out. Anything else? Yeah, no, okay.
Can I ask, so staff recommendation would be a 60-day public comment, because that would give significant time for commenters to weigh in, but it would also bring it back right after at the May 6th meeting. It's too tight to get it back for March, and then it's the symposium in April.
That's okay.
Sounds good to me.
Yeah, from the public comments we got last time, I think they'll be muted, but if there are some, this walks closer to the line of suggesting that there might be comments from experts who say, no, I want a brighter line. But we're not saying you don't have that if you're like Bill. We're saying don't walk too close to this area. So we'll see.
Be like Bill.
Like Bill, you know.
Don't be like Bill. Don't get you in trouble.
Okay, so should we take the vote? Where's Angela?
You need a motion.
Oh, right, sorry. Can I get a motion? To vote it out? Somebody?
I'll
move to vote it
motion
out.
Yeah,
vote it
make the
out.
motion. Yeah,
Second,
yeah.
I'll take the vote for 6-day public comment for 20-0001. Emil, Ali, Brown,
Yes.
Coleman,
Yes.
Desmond, Carter, Eleanor. Eleanor, do you want to vote?
I think she may have lost audio. Eleanor, can you hear
oh,
us?
I couldn't hear. Yeah, thank you. Yes.
Okay, thank you. Mohebi? Munoz?
Yes.
O'Reilly?
Yes.
Windexter?
Yes.
Robbie? Riley?
Yes.
Shivers?
Yes.
All right, 8 yeses, and the motion carries.
Okay, so Dan, you're free to leave.
Thank you.
You need to go. Let's go back to the thing, the opinion log. Sorry. The afternoon drowsies.
Would you like me to reshare it?
Yeah, is that okay? Okay, so I think, what do we want to do now? I mean, we have a pretty decent work plan with the existing opinions. So now the question is to go through this list. This is more like, you know, new opinions, right? And go through, I guess there's two tasks here. Figure out the topics that we actually want to put on the, you know, the schedule for the year, but also determine which topics are appropriate for opinions and which may be or you know, which can be articles or alerts. So I don't know how we want to tackle that. We want to just go through them one by one. Let me add, I didn't do it and I apologize. Erica and Angela, did anybody respond to the priority, you know, the prioritization of the ethics opinion topics? Do we have that?
I responded.
Nearly everyone did respond. And there is,
I'm the bad guy.
and there is zero consensus. The most any topic got was 2 votes of them all.
Okay.
So
What was that?
and let me pull it up for you. And I'll just, for what it's worth, I don't know if this person wants to state their own vote, but one person voted for no topics and to finish what we have started.
Wait, say that again. Sorry.
Oh, there was a vote for no new topics as well to work on, that there's a sufficient inventory right now. Although one new topic was voted on earlier already.
The ethic or the expert, is that a new topic? We're considering that a new topic?
Yes.
Okay. Well, okay, what's the topic that got 2 new votes? Or do you want to share your screen as to the
I think Angela and I may have to race to get to them. Eleanor.
Yes.
Go ahead, Ellen.
I think we also agreed to revisit the AI guidance. So I'm not sure that's on the list, but we should add that to the current inventory.
Well,
if that was in fact agreed.
Okay. I don't know. Well, okay, let's, so are the voted on topics, are they included in these, the yellow and blue topics?
No, so these weren't even up for vote, so to speak. So what you voted on was a decision as it related to prioritized opinion. So it was the opinion inventory, which was opinion requests from third parties, if you will. So it was the longer list that includes the CDAA request, the district attorney's request, a request regarding 8.3, a request related to Rule 4.2 that we touched on briefly at the December meeting. And my recollection is there was a sense that everyone thought it was more of a legal consideration as to whether the which evidence code versus rule of professional conduct are kind of a preemption issue there. And then to look at the topics that the ethics hotline had prepared as basically an inventory of opinions that need to be either updated or other opinion topics that they think there is a lack of authorities to provide to callers.
Okay.
And with that, Ange, were you able to pull the list that we have?
I remember giving it to you in an email. I do have a list of everyone's names, so do you want me to project that or?
Sure. Why don't we do, if you have it available, that'd be great. Thank you.
1 moment.
And I'll stop sharing for a moment here.
So Eric, oh, well, I'll wait.
Okay. So wait, can we make it bigger? Huh? I mean, I'm wondering if is this a good task for a working group to put together some recommendations? Even though.
You don't have mine on there, Angie. I said no new topics.
Oh,
Okay.
I'm not doing that.
Okay, yeah.
There,
All
right there.
I knew it was you, Raquel.
I was gonna guess that, yeah.
Well, because I already said it, right? Like, like we already have stuff we don't do. I don't think we need to add anything right now, but hey.
And I'm trying to locate it. I think, and I can't remember if Ange put it in a chat or how I got it, but I think there's a tally that you had too. Am I? misrecollecting.
Can you scroll up above me? I think there was somewhere between me and Nima was some, yeah, okay. Novella.
Yeah, I like the immigration. I mean, how are we gonna do this? How are we gonna kind of figure, I mean, well, maybe we should take a poll well, take a poll. Does everybody agree that we want at least one more new topic, new opinion? Well, at least a new opinion, just start there for this year. Should we take a poll, Erica or Angela?
You certainly could. That would be a second new topic essentially, though, just to make sure.
All right. Well, in addition to the expert, I mean, the trust accounting expert, whatever the topic.
Angela, let me share my screen. I found the tally that you had, and I think that may be an easier way to look at this.
Oh, good. We're really just narrowing it down to
on deck
one topic. Yeah.
How many do we have on deck right now?
That we have
just, that we
pending?
would just, yeah, the green ones. Plus,
Yeah, but
yeah, I think, yeah, how many do we have of the green ones?
hold on, let me go back
Those
to
were the
my.
ones that were out for comment, right?
No,
I
those
mean-
are just ones that are at some stage open at different stages.
I think the only one that needs, I want to say that needs work.
Oh, Cassidy.
Like more work than just like, I'm trying to
No,
remember now,
Cassidy.
like what we just discussed.
There's
like the flat
11.
fees.
There's
There's
11.
11.
That was all I want, not the justification of how we can add more. We have 11.
Well, I
And-
know, but
And how many months do we have? We have about 11.
yeah, but we can get one started.
Cassidy, no, we're not good at that. We haven't demonstrated we're good at this.
Raquel, we're gonna take a
multitasking.
poll. We're gonna take
Okay.
a poll, but first we're gonna look at the ones that we have pending, because most of them are 75 to 99% done. And then there are, that's what I'm trying to figure out, are how many are still need significant work.
I think that's a good way to look at it.
Yeah.
You can
And
evaluate it.
so, like, we just voted out one, so that's, that one's potentially, let's say that one's 99% done, assuming public comment.
Right. No.
Well, but I mean, then we're getting into, okay, well, we don't know what public comments are gonna be. It may send us right back to the drawing board, but we can't really be, limited by that. I think we really just need to look at the ones that are, that really need work, that we know now still need work or significant work, so we can, budget how much we can take on that's new. So I forget, is flat fees still still needs significant work, is that right? Because we just formed a new working group for that one.
No, flat fees just came back from public comment. And so there's a question for the now fully formed working group of Brandon, Raquel, and Nima as to whether to modify the opinion to address more than milestone payments, to essentially address hourly tracking of flat fees. Last round of public comment, we got a comment that said don't do that, because then why bother with having a flat fee? And this time around, we got a comment that said do that, because it's much easier to track as an arbitrator in fee disputes. And so I think that there's just policy decision to make here as to how that should be done and what COPRAC thinks the advice should be, as is if it should be, you can do this in several ways, including the following, or it's the committee recommends one way of handling this. And so forth. So
Okay.
I would say that one probably, depending on what the committee wants to do, is close, in the sense that if the committee doesn't significantly modify it, it'll be ready to be voted out at the March meeting to the board.
Okay.
Excuse me.
Okay, that's good. And so, and then, just go through it quick. Conversion clauses, that one is,
That's going to need another public comment period, most likely.
that one's like the work on it is pretty much done. And then ethics of in-house counsel, I know that one, that one should not take that much more time. Although I would say that one's like 85% done to 90% done. Cryptocurrency,
I say that's probably about maybe like 70%. I don't know if Eleanor, if you disagree with that.
But it will require at least one, possibly two public comments.
That's right. That's right. Yeah.
Yeah.
Right. And this committee has not seen it, so we don't really have their input.
Oh.
so that
I'm
one's,
saying, right, so maybe the committee is at 70%, but the working group, I mean, it came to the committee, but it's totally different people on here now.
Got
than
it.
when
Yeah, so
it-
that
than
one's-
when
that
it was
one's-
presented.
yeah, so that one's one that's, it can be in a category that's similar to a new opinion, or, it still is requiring some
Percolating.
work that, yeah. Okay, so that's one.
Would it be helpful if I show what is in the work plan that we just discussed?
That would be great.
Yeah.
Thank
I didn't want you to, like, you hadn't done it, you finished it yet, so, yeah.
Well,
that'd be great.
it's a draft, so
Right.
but it only, so far, for what it's worth, it only addresses ethics opinions. Basically, we haven't gotten to if there's anything else to include. Obviously, the symposium would be in it, but if there's anything else worth including at this time. So based on the conversations, I put interim steps, and then recognizing that this is in some ways at the subject to public comment, I put a proposed deadline based on the current status of these opinions. And so as you'll see, most of these are Q4 of 2025. A few of them are Q3 2025. Those are the ones that have already gone through 2 rounds of public comment and have unlikely to have few changes, or about to go out for another round and likely to have few changes, like 20.001, like we just discussed. And then as we scroll through, so most of these are this year. And then crypto, for example, I put as Q2 2026 because it needs to go out for at least 1, but it's more likely to be 2 rounds of public comment. And then this I need to modify, but it would be and so forth. So this is there's a lot here that in theory could be done this year. And if so, everything will be at the beginning stage except for cryptocurrency and the new one, the handling retainers and fees, if in attorney adjacent work, if that's actually an opinion as opposed to practical guidance. So that would mean there was really 2 on deck for 2026. Again, with the giant assumption that everything we just discussed gets done in 2025, which I think that's over ambitious for this committee at this time.
How does this number compare to what we put out last year? Realizing, it was a different committee. We've got
So last year the committee put out one truly new opinion, and then modified 2 others. So modified colleague impairment to address 8.3, and then modified the arbitration advisory to reflect the PEC decision. But there's other work that gets done by this committee that's not, like those are the deliverables. Those aren't, that's not the work.
Understood. This is helpful. Thank you.
Yeah, I'm just trying to gauge I just feel like we've got a lot in the pipeline that's almost out the other end, and then we're already, and then we have nothing new, you know, so should we just keep it flowing? Or should we just get this all done? You know, and get to the end of the finish line for all of these and then start something new, you know, we don't have anything that's, well, we only have like oh, maybe one or two that are at the, like the 25, the new, well, that's a new one, that's, we're considering that a new one.
We could agree to do something in between and just take on a new one the moment one goes out for public opinion.
Right, so I'm just trying to like, you know, we
Kinda
shouldn't be
onboard
so
them that way.
rigid. Yeah. Yeah, so keep it manageable, like we shouldn't feel overwhelmed, but we shouldn't, you know, stop considering new opinions just because we have ongoing opinions that never seem to end.
Another option, and just recognizing that Raquel has her hand up, is that you could just put on here for typically the committee reviews new opinion requests and whether to take on new opinions on a 6-month basis. So you could just put consider new opinion topics by Q2 or Q3 2025. And at that time, decide to take on new opinion topics. And that'd probably be a good time to revisit the work plan, take an inventory of where you are on these things, and then decide if it's actually the fact that 3 of these are done at that time, or if we need to, if you need to move the timelines.
Okay, what can we do? Why don't we can we put together a working group to actually make some recommendations about,
Cass, can I get recognized?
oh yeah,
before
I'm
you
sorry,
Move
Raquel.
into action. So I have one comment, which was what Erica just said, based on the completion dates we have that we revisit in Q3, some period during Q3, where we are and what we have, and make a decision as to whether or not we're gonna take new topics. We could still today go through and decide these are the potential ones that could be. So we'd already know, but we don't have to. So that was my comment. My question is, this work plan is covering from what's the time period that we're considering for the work year?
It would be the 2025 work plan. So
I know,
this,
but so what's the date? What are the dates? I just want to make sure. Does it start in January through September?
would, yeah.
What is it?
It's all of 25, so January through December. The benefit of this being 2 things. One, I think this is an option right now for this committee, right? So the committee is not required to do a work plan at this time. Another option would be to make this through terms. So there's people that term off effectively before the October meeting in 2025. So the work plan could be essentially through Q3 of 2025, and then a new work plan starting thereafter. But I think that it's just frankly easier to track it by the year as opposed to the term.
So you're calling it 2020, 25, 26, but it's only based on what you said through calendar year 25. I'm trying to get the number of months so I can understand how
I'm calculating it as 25. I was just based on our existing inventory as I was putting deadlines in.
You went into 26.
Because I don't think it's realistic for some of these to be done in 25 based on the current status.
Oh, yeah. So then this is not a 12-month. If you're going to Q12, what is that? That's 15 months. 15 months.
Oh, yeah.
Right.
But I mean, crypto could come off of this work plan because we still have the opinion log. If you want it to be a true, what are we actually doing in 2025 work plan, it could come off.
Thank you for the clarity.
Sorry. Okay, so two things. My suggestion is to do a working group to examine whether or not we can take on a new opinion and make a recommendation at the next meeting, and what the topic should be. Or we just do that now, as a committee. I just feel like we have a bunch of other stuff to get to today, that I want to get voted out. So maybe we, instead of making a snap decision right now about taking on new work, we have plenty of work to, on our plate right now. But I don't want to lose sight of new opinions and new ideas and that sort of thing. So maybe we just delegate that to a working group and have a more organized discussion at the next meeting. Does
I like
that?
the idea.
Can I make one suggestion? Again, recognizing that you can always do things sooner rather than later. If you wanted to establish that working group to consider these things, as opposed to making it by the March meeting and then missing that deadline, you could always make it. It doesn't need to be by March necessarily. I think maybe to Raquel's point, I guess, I think that it would make more sense to the committee, for the committee to get an opinion moved forward as opposed to a new opinion topic move forward by March. Because it's only 5 weeks away, basically, till that meeting, 5 or 6.
Wait, what do you mean? So I'm getting an opinion. What do you mean getting an opinion moving by March?
I would just hate to divert resources from the momentum on all of the existing opinions at this time to have, instead of taking the time for those opinions, for a working group to consider new opinions, because it's just gonna delay what's in this work plan essentially if those targets are missed.
Are there any people who are not on working groups right now?
I think that's kind of the analysis we need to do with a working group, is like, what's the utilization?
Yeah,
How many
what's the
things we have folks on leading, and
okay, well then go ahead, Eric.
I was gonna say, does anyone really have capacity to take this on right now as an individual?
Take what on, Erica? What are you asking?
Take on coming up with a way to determine what the new opinions should be, if any, based on whatever the committee decides should be priorities. So be it that prioritization list that's currently a draft, or be it something else. I think that's it's not an insignificant amount of work.
Okay, I appreciate that. Well then let's, Eleanor, were you saying something?
oh, I was nodding. I think I know where you're going. I wasn't saying anything.
Okay, well then let's form a working group to have those recommendations by the May meeting. Is that the next one after March?
Correct.
Okay.
That's
Who?
I'll
how many people
volunteer
are
to be a
here?
part of that group, because we should be done with crypto hopefully by that meeting, before that meeting for the committee. So I'll have some time. I'm happy to be part of that.
Okay, and I will too.
I would just like to go on the record. I would not in favor of it, but I understand we're gonna go in that direction.
Well, that's what the working group is. I mean, so part of the working group is
I'm not in favor of having a working group. I think it's something we should do together. I don't think there's that much advantage. But I understand we're gonna go that way. But since we didn't vote, you started off saying take a vote. And
I know. We
moved
can
into it. So I just want to go on the record. I don't think it's effective for us, but.
Okay, well, let's take a vote then. I don't want to be, I'm not a dictator.
I didn't think you were a dictator, Cassidy. I think
Part of the
you're
goal,
a
right,
dictator.
is to come
You're a
up. I mean, I
chair.
think
You're just a chair.
the working
Yeah.
group could share ideas. I'm sorry, Novella, I see your hand raised and I just chimed in here. I'll defer. Although I guess Cassidy needs to recognize you.
No, it's okay. Novella, go ahead.
Yeah, I like the idea of putting on the working plan, like when we're gonna pick new topics. I'm probably agnostic as to whether we pick a new topic like now versus like a couple months from now? And then with the selection of the topic, I wonder, because we already got like a straw poll from people about what topics they prioritize, if we narrowed it to just the ones that got more than one and voted, if we could develop consensus out of that. Like I sort of share Raquel's hesitance about a working group picking the new topic as opposed to all of us picking it together.
I don't think that, oh, sorry, I'm gonna.
Go ahead. I'm sorry. I have an emergency email. I just need to send really quick. So just please keep talking. I
Okay.
apologize.
No problem. My one idea for the working group would really be to just organize the information. What have we done? Maybe by topic, by rule. Like I was kind of thinking we could get a little better organized and understanding what we've done historically, what's out there, where the gaps are, you know, talk to staff about what they're seeing and kind of come back, not with anything that's set in stone. Hey, it's these two topics, but here's why we think we should focus in these areas. And if the committee has different opinions after seeing the data, they can go a different way. I don't think it needs to be set, but I do think kind of pouring through the information and presenting it in a more organized way, hopefully with the help of staff, could be really useful to the committee and not necessarily a useful endeavor for all of us to engage in. That's kind of what I was envisioning.
Sorry,
Go ahead.
I'm missing my raise hand function right now, and it could be because I'm screen sharing. I would actually agree with that. I was looking at the list with the tallies just very briefly, and many of these are covered by existing opinions. Maybe they're not California opinions, but now that California largely follows the ABA rules, maybe they're one of them, the no contact rule. ABA issued an opinion on that, I think, last year, and our rule is substantially similar in that space. And so recognizing that two people were in favor of moving that forward, maybe knowing that there's a recent ABA opinion on that would be helpful. Maybe it won't, maybe they already do that. But that type of thing where it could be, here's the opinion request we've received, here are the opinions that exist in this space in other jurisdictions that have similar rules to California's, and then providing maybe education in that space or resources in that space that could be helpful for attorneys. Now that California is much more aligned in their rules, at least the numbering, if not the substance, with other states.
Okay. So, okay, I'm sorry that I missed the first part of what Eleanor was saying. So we want to kind of have a more extensive review of new topics based on even out of state opinions, you know.
Again, it depends on whatever the committee obviously wants to do, but if you're looking at, if the thought is that they are prioritized and you're looking at that draft list, I mean, maybe that's something that a working group would finalize. Again, this is resources that I'm not sure the committee has the bandwidth to, this is going to take time, and it could be with staff, of course, but I'm not sure this is something that committee wants to prioritize or has the capacity to prioritize. But if you're looking at the prioritization topics, perhaps a topic to consider is, you know, if there's, you know, in-state authority in this space, but also out-of-state authority upon which someone could rely in this space as a basis for consideration before taking on that new topic, especially considering that there are 11 actively pending with the committee.
Is there
in
an
various
for it?
stages.
Do we already have an opinion on point? Does the ABA have an opinion?
Yeah.
On the same or a similar rule? I think those are like coming up with a model for how we evaluate these things, or at least, you know, relevant questions to ask when we're evaluating them, I think would be useful in my view.
Yeah. Yeah, so I mean, and again, it's something, you know, that then it makes sense to just, it's a bigger project than just, you know, like putting up on a dartboard and picking topics.
So we don't need to look at it as like topic selection, but more about like, you know, a model for how we're going to evaluate topic selection, perhaps. Maybe that's more palatable to folks, because I don't think anybody's trying to force anything.
Well, I mean, are we getting back to the, the finalization of the recommendations? We were gonna put together, and at the beginning of our meeting, we were talking about finalizing the recommendations for assessing opinion versus article and, the schedule and all of that. So do we want to just task this working group that we're talking about, which is not just me and Eleanor at this point, with all of that? Because I think we were gonna come up with the final, I mean, these final documents, the work plan, the schedule, whatever they may be, as sort of lasting documents. So that's gonna take more time. Are we talking about one working group and kind of one big task, I guess is my question.
So the thought could be that this is something that is due back to the committee in about 6 months, when normally the committee would revisit opinion topics anyways. And then, I sorry, not to sound like a total broken record, but then you could see how far you've gotten in the ones you already have 6 months in, and that leaves 6 more months of the year to get started on other new opinion topics, so that it come 2026, assuming you got the work plan accomplished, you would have a couple more in the queue, so to speak.
Okay, well, let's do that. Then let's set like a 6 month out. So we're talking about July now, right? And we'll have this sort of, what are we gonna call this working group? The planning committee or something, like the future planning committee or something. And we'll just, we'll kind of just tackle all of these sort of, forward thinking plans that will include new topics, but will also include the structure that we're gonna need, that we're gonna pass on to future generations as we, figure out how best to organize and keep work flowing. So right now it's just me and Eleanor, right? Does somebody else wanna?
I can join.
I'll join.
Thank you, Nina.
Okay, thanks, Nima.
And Vikita too, right?
Yeah.
And
I'll
Vikita,
join.
okay. Great.
That gives us critical mass to divide it up.
Yeah, and so we'll come up with a better scope at our first working group meeting, and then that'll give us 6 months to just, have this plan. And so, we have a firm deadline, which would be do we have a July? Yeah, July meeting.
So that's technically, I think, Q3.
And I think, Erica, before we lose you, your thoughts on this would be incredibly helpful to us.
Yeah.
And whatever data you can share, or you think we should collect, that would be useful.
Yeah, happy to. We have all the data as far as like over the past several years, how many opinions have been issued for public comment, if they've been issued twice in that same year on the same opinion, and so forth. And I think just looking at that to create realistic expectations, that was what was done as far as creating like a recommendation to publish 2 opinions a year, because that's really what's been done over the past, since COVID, essentially, which is, quite some time at this point. And that's about when the committee became the current size that it is as well. So what is on here is much more ambitious than 2 opinions this year, recognizing, however, that there are a lot of opinions that are very close to being done. So this could be a different year, and then going forward for 2026 and so forth, maybe that 2 opinions a year makes more sense.
Okay. Okay, so do we want to move on then? So we don't need to move on to the rest of the log, right?
No, I don't think so. I think the thought is that you would revisit that. You would visit that as part of the recommendations that are going to come in
July.
July.
Yeah. Okay, so let's move on then to the next agenda. Anything else about our planning as we wrap up this planning item? No, nobody. Okay, good.
So that, just, sorry, Cassie, so this isn't, or just for next year, this isn't currently required of the committee to do this exercise. Once it becomes required, you'll have to probably vote on the work plan and have it fully adopted. You could do that at the March meeting if you want to, but it's not required. I'm not sure if it will be required, if that's something the board is going to adopt, and if so, when, but just for future sake.
Yeah, so I mean, like the work, that was kind of the initial plan, was to vote out the work plan, which we have completed, but do we have it complete enough? I mean, we can vote on what we have now, right? I mean, okay, so I have a question. So the work plan that, let's say it is required, then, and it has to be voted out, then can we change it? You know, like, is it a living document, or is it something that we vote on and that's it and we have to stick with it and we, you know, I don't really understand how that works in terms of requiring, if it's a requirement of the board.
Yeah, so it's, keep getting back feedback. It's really for accountability. So if the board is approving some, you know, whatever's on here, if it's voted and approved by the board, you're gonna have to explain why it wasn't done, essentially, to the board come next year. So, I mean, there's a benefit to giving yourself more time here if you think more time is necessary, because it's like a deadline. It's, you know, why did you miss your deadline? And, you know, so that's the issue here. This is very different for this committee. I recognize that this committee has never had to do this. It may be helpful for the committee to get things moving forward, so this could be of benefit. But yeah, essentially, you know, if there are 11 things on here in 2026 and it's given to the board, and then come 2027 and only 2 of them are done.
Yeah. No, I understand that. It's just like when there are deadlines that we don't, you know, when there's uncertainties, you know, and that we are going to need to adjust as we move forward, say when there's public comment and, you know, we didn't, you know, like what we just already discussed. So that's all.
And that could be explained, of course, you know, we thought it was done, and then we got this public comment out of left field that raised a really good point that none of us had considered. So, I mean, there's always an explanation, but I think that just having the sense that this is to hold the committee accountable in mind when it's being prepared, and especially once it is formally approved, is something to consider.
Okay. So do we want to vote on it today, or do we want to wait till the March meeting?
March.
I will fill in the rest. So there's a few, there's 2 things missing.
Yeah.
One is the arbitration advisory, which may get approved at March, but just to get it in here. And then the symposium is the other thing that would need to be added just to the education area. But I can fill in everything else, and you could review it in advance, and then you can vote to adopt it or modify it and so forth at the March meeting if you'd like.
Okay, let's do that. All those in favor? Yeah, okay, let's do that.
Yeah, Cassidy, and your working group committee, could you guys also define in your work what's the scope of an opinion, an alert, an article, guidance, all the different.
Yeah, that'll be part, yeah, I mean,
That'd be part of your group?
yeah, because that's part of what we discussed in the beginning. So we'll make the recommendations, because, you know, the idea is that we are creating criteria, you know, for our committee, but committees in the future. So we're creating this guidance that's concrete. So yeah. Yeah, okay. So let's move to item 4.8, I believe, which is the ethics article on activities that threaten the safety of judges. Is Deepika here?
No, she's not here today.
But okay, so, but she drafted, you know, we drafted this as part of the working group. I think we had it, did we have it for review? at the December meeting? I don't think so. This is
No,
brand new.
it was high level discussed, but there was no document at that time.
Okay. So this basically mirrors the, you know, it captures the concerns of the judges that well, of all the judges and the comments to Rule 8.2 and 3.6 and 8.4. Did I say that right? That we're going to be discussing. Sorry, 3.6, 8.2, yeah, and 8.4 that we're going to be discussing next. But so this is sort of a companion article to that. And instead of doing a whole opinion, this is basically our first article or alert that we want to push out, covering basically the limitations of free speech for lawyers who are commenting in the public sphere about judicial officers. So I think this is a great article. I don't know if anybody has any revisions to it, but I would propose that we vote it out. So if there's any questions or comments, feel free. Raquel?
I did think it was well written. There were two things. One, do you all who were on the subcommittee think that it meets what the judge's desire was in terms of the tone of it? Because they're feeling very threatened. So that was, given you all have been the ones meeting with them, is it strong enough, I guess would be the word. The other thing is around social media. Not what you're posting, but often what you're reposting or what you're liking or doing different things, which there seems to be some wiggle room in not only what has been written, but how I've seen people say, well, it wasn't me, I just reposted something, but the thing that they reposted goes, in this case, if they reposted something that was against this, is problematic. So my thought is that there needs to be some way to incorporate that those kinds of things are part of this as well. Because I see people doing that more and more. They understand I'm not going to write it myself, and they sort of try to wiggle around it. So those would be my two comments, but I thought it was very well written.
Okay. I think the judges, did we circulate this to the judges, Erica? No, we didn't. But I do think it captured, this is a product of several rounds of meetings with the judges and going over, what we can and can't say, basically, as far as limitations of free speech, having George Cardona come in and give us his input. So this is consistent with all of the meetings that we had. And I think that it's, it definitely captures the concerns, taking into account the fact that there's not a whole, we had certain limitations given the free speech issues. So are there any other, we could revise it to address the social media issue, Raquel, but what I want to just get it out because I think it's good. I think it's good to get this message out as soon as possible. So I'd like to, anybody other comments on the article?
Well, I'll just to the reposting, because I think that's a really valid point. I think though that it would need to perhaps be the First Amendment analysis would have to be looked at from that perspective as well in more detail in this opinion, if anything were to be said about it. Or at least I would feel more comfortable if that was explored before that was added on the fly, which can happen, I think, before, but I just don't think I would add that without exploring that issue a bit more.
To the alert? Or you used opinion, but you meant.
Sorry, yes, to the alert. Sorry. Yes, that's going to be a challenge.
And what's the rush?
So we want, well, because I think that we want to get it out. I mean, this is one where it is we've been meeting with the judges for several months. They, they want, the comments to the rules are, aren't going to become comments for a while because they have to be approved by the board and have to go through public comment. So I mean, I agree. Well, in my personal opinion, I want to get this message out there, and I think it's a good article, and it captures everything that we want to say. I just don't want to, what's the saying? I don't want the desire to be perfect get in the way of the good. I think expediency is a valid consideration here. Those are my 2 cents. And if everybody else can disagree. Novella?
Yeah, I thought it was clear and I like that it was brief. With the like reposting issue, I think I share Erica's hesitancy about like, well, is that going to be a more complicated First Amendment analysis? So then having not thought through it thoroughly at this point, I wonder if that would fit in a alert or if that would need to go in like an advisory opinion or something else, just because I don't know, like one of the factors is like how complicated it will be.
Yeah, so the question is do we hold back the article and do that analysis and plug it in if it's if it doesn't complicate it and make it too long into a constitutional law treatise, I mean, not to be hyperbolic about it, but makes it more complicated. So do we want to take a closer look at it? Do we want to hold it back until March and vote it out on in March, or do we want to vote it out as is? Do we want to take a poll?
Erica, are you studying something?
Yes.
That we're talking about?
I am listening, but yeah, I'm trying to look at reposting.
Okay, yeah, I mean.
Well,
I mean, to me, in today's world, I mean, like I say, the people are more likely to do that than to say, I'm gonna kill you, unless they're in the courtroom, right? I mean, they're gonna.
Well, it would fit into the same, so the reposting, what is the content of the reposting? Is it, I'm gonna kill you? Is it, does it fall into the 3 categories, and the 3rd category is, is it an objectively verifiable fact that, that is false, so that it does fall into the exception. And so just by virtue of reposting it, are you subject to discipline if the content falls into that 3rd category? I don't know the answer to that, but I would think so. You're making a conscious choice to adopt those words, right? Whatever they may be. But we don't have that separate analysis in here. So I guess the question is it, does it provide enough guidance on, the First Amendment issues sort of in a general sense that the reader will, infer that, yeah, I could apply to reposting or would at least trigger the reasonable lawyer who's about to repost something. Hey, wait a minute, I read this article that talks about the limitations of the First Amendment. I could be in trouble for this. Is it enough to give a warning even for a reposting without explicitly talking about it? So, I don't know the answer to that, but that's kind of the purpose of this article, which is to raise it. I mean, this is one of the raising of the issues type of thing, and to generate awareness, among lawyers especially those that may be thinking about, who's angry at a judge, and is going to be careless in their public comments. you know, that's my take. It's just, we're raising awareness here. And I don't know if we need to get necessarily specific about this types of, you know, communication, whether it's a posting or a reposting, or it's, you know, anything else.
We have two really good recent state bar cases that came down on either side of the issue that we could use to anchor our analysis on, you know, to show both sides. I mean, could the article just kind of, because not a lot of attorneys read state bar opinions. Is it possible, like, could we use this as like a debrief and show these two different opinions? I'm thinking specifically about, and I'm going to forget the attorney's names, but I'll remember their conduct. Well, one is Marla Brown on the one side, and then the other is the succubus, who the guy is escaping me. He's actually a very good writer, but he uses his wit for harassing judges. But you know, in his case, they found that his speech was not protected and it was a disciplinable offense. And then for Marla, they found that it was protected and that it wasn't disciplinable. So, you know, could we use those two as kind of like our juxtapositions? And just do like a brief on recent First Amendment cases out of the state bar?
Yes. I'm sorry, I'm pulling up the article.
Carrie, what was the Marla, I don't know, the Marla Brown, what did she do?
She was an attorney that during the riots that were happening in the early days of COVID, because of some of the recent like police brutality cases, she was posting things on Twitter, and I can't remember the exact content of what it was, and I can't remember if she was liking other people's comments or reposting people's comments, or if they were her own. But that was just one of the issues. Some other ones was that she might have been holding herself out to be an attorney for the LAPD police union when she probably actually wasn't, and there were like a lot of layers. But all of the facts are interesting to kind of tease apart for the article.
Thanks.
Yeah, I mean, we don't have that one in here, but we have Pavone.
Pavone, that's
yeah, that is in here, but it's not discussed as far as the facts. I mean, so I guess what you're talking about is, you know,
I mean, both cases kind of outline the contours of what we're talking about in different ways. Like they got the line, and then the court found one versus the other.
Yeah, I know. I mean, you know, then we're talking about more of a, you know, briefing of, you know, analysis of the cases, or you know, briefing of the two cases to illustrate what you're talking. And I'm you know, that's certainly illustrative of what we're talking about and would be helpful. But we're talking about going back to the drawing board. I mean, and I don't think it would be hard. You know, it's not difficult to incorporate those two cases in here.
I found Marla on Twitter.
Oh gosh, she's still tweeting?
Huh? No, I'm going back to what
the archive.
I mean, I'm just going back. I just looked at her Twitter, going down her timeline. She was getting congratulating for beating the state bar, but I guess at one point she did not.
I don't know that including the Marla Brown decision helps the cause, because it was dismissed.
Right. Yeah, I mean, we're gonna say like, here's what you can do.
And so you're giving really a path to what you can do, which was liking and reposting things, which is the opposite of what you're trying to have happen here. And then Pavone, for what it's worth, really focuses on the fact that much of what he said is what we kept getting stuck on the word last time, conjecture. It can't be proven true or false. And so for those reasons, it was also found to not be disciplinable and subject to First Amendment protection. So those cases are very interesting cases, but I just don't know that they accomplish what this opinion is trying to do. which is to say, please don't threaten judges, essentially. I mean, to me, those two cases say, here's how
Right.
you can do it successfully in many ways.
And it's so sad that we even have to say this to attorneys. I mean, that to me is the thing that's just like, have we really gone this low?
No, but I think,
I mean-
our opinion should also align with how the court is currently. Like,
Thinking
I
about
don't
it.
want our guidance to be wildly out of alignment with the nuance and that the court went through in deciding both of these. And then there's the third case that's really interesting, which was the guy out of Culver City who I can't remember, but he was harassing, I think his name was Chris Cook, and he was harassing the Shepherd Mullen attorneys, and he was saying super anti-Semitic and homophobic things to them in like settlement discussions. And that case didn't go to the court, but we do have a very detailed stipulated disposition in that case. So, that one's also public record. That I don't know. I think that it's such a nuanced analysis that I just want to make sure that our guidance is not out of alignment with how the court is viewing this conduct.
Well, I don't think this article does that. I don't think it's out of alignment. In fact, we talk about Pavone being, creating a limitation, because it says the judge did not find his statements to be constitutionally protected. No, well, Pavone was right. He was culpable. He was culpable and not culpable in some of his statements. It depended, but it's not. We're not out of. I don't think there's anything out of line here. It's just, we're not writing. Again, this is about like raising awareness without getting into a full-blown opinion about, the nuances of it. I don't think we can do that in an article or an alert. So I don't think we should be going through all of the cases in this article. They're not, I think it's just, I like the brevity of it. And it highlights exactly what we want to highlight, that there are limitations to free speech. So, oh, sorry, Novella, go ahead. And then Erica.
Yeah, I guess back to the initial question, like I wouldn't mind if we took more time to add like a sentence or two as opposed to like a full-blown analysis of all of the cases, although I do think that could be interesting too as like its own piece of work, like something else, and would be informative. And then I guess maybe I'm just super like risk averse, but when I see the case, I don't think like, oh, this is how I can like walk up to the line, because to me, you shouldn't even want to be prosecuted by the state bar. So I wouldn't even read the fact that like ethical charges were brought. I think hopefully for a nice chunk of people is enough to be like, whoa, there's some lines here I should be careful of. So yeah, I guess I don't see the state bar opinions as like creating a roadmap for how to harass without getting in trouble, because I wouldn't even want to be prosecuted.
Yeah, that's a good point. I mean, the fact that there are, that there was a prosecution and you beat it back isn't necessarily a huge win. Go ahead, Erica.
I was gonna two things. One, there's gonna be a symposium on this topic, or this will be part of the symposium. So all of these cases could be raised at that, and discuss the nuance between those, as well as Yagman and several others that are in the article. And then additionally, what could be considered is adding like relevant First Amendment. If this is posted, it could be, here are some other cases that discuss, for more information, take a look at these, especially because Marla Brown, it's not published. It was dismissed at the hearing department. So to find it is going to take someone going to the state bar court website anyways.
Can we link it? So you're suggesting we can't link the Marla Brown case at all, or would we just, or would we, sorry, go ahead.
It's still, you're still able to find it. It's just, she's now referenced in just by letters, but it's MAB in the opinion now.
Right, but it's still an unpublished opinion, so you have to go into Odyssey.
Yeah. But OCTC took it up to the review department, I thought. No? Did they not seek review in that case?
I'm in Odyssey, I'm not seeing it, but I could be not in the right case number.
Okay, well, because I know that there are cases that have been dismissed, where now the respondents are just referred to as their initials, but are still cited for, so, like, I know you can screen them.
Regardless, we can still link it or reference it in a separate, yeah. If we have a separate page that says for more information, you know, see these resources. Right? I mean, I like that. I mean, okay, so I like that idea, but I also think, okay, I guess we can wait until March to vote this out. Can we take a poll as to whether or not you want to vote it out today or wait until March? Erica?
What are we waiting to March to do? Why would we?
To add a few sentences to examine whether or not we want to add, you know, not a full-blown analysis, but add a few sentences about what the, you know, more examples of what is and is not protected based on the cases, either Marla Brown or Pavone or Yagman or anything else.
Thank you.
Is that okay? And then so and I can appreciate that if we had maybe a paragraph of examples of comments that would fall under like the third category, because I think everybody pretty much knows what threat, like actual physical threats are and incitement are. And then what it looks like, what the posting looks like. So, you know, whatever references we want to additionally include in the communication about the article. And so that will be the subject of the March meeting to be voted out. Or do we want to vote it out now? Can we take a poll? Is Angela there?
Yep, I'm here. So we want to say yes for voting it out now and no for keeping it for the next meeting, correct?
Okay.
Okay. So I will take votes. Ali? Brown?
No.
Coleman?
No.
Desmond? Mercado?
Abstain.
Mohebi?
Yes.
Munoz?
Yes.
O'Reilly? Poindexter?
Let me just make sure I'm clear. Yes for voting it now or no for voting it now?
Yes for voting it now, no for.
No.
Okay.
Thank you.
Riley?
No, and I am willing to help with the little blurb.
Okay, and Shivers?
No.
No, okay.
You said no. Okay.
So that's 5 people for no and 2 people for yes. So it'll carry over to the next meeting.
November. Okay.
Okay, Carrie, you are in charge of the final revision.
Okay.
And can we do that? So she'll be added to the working group. Is that right, Erica? Or is that okay? And I'll work with you too, Carrie. Just we can work on it together and then we'll get it ready to go. So
Okay,
thank you.
Erica, can you check on your end from like the state bar's perspective if there is any issue with us discussing the MAB opinion.
As long as it's public, that there shouldn't be. Which it is a public, I mean, you can discuss whatever's in the public decisions. It's
Yeah,
just
I mean, and I-
published versus public.
Yes, and it was for sure public because there were like a lot of articles about it because I learned the disposition of it long after I left the bar. So
No, it's a public case. It has a case number and everything, so that shouldn't be an issue.
Okay. Okay,
So,
perfect. And
so
I'll try-
Erica, you were concerned about something had antitrust, I think you said. Is that?
First
not-
Amendment issues for, if we're gonna go into the posting, reposting analysis. But it sounds like that will happen because we're gonna discuss the Marla Brown case, which I believe, I haven't read that case in a while, but I believe that's the crux of the issue in that case, is she was liking things and supporting them, and be it liking or reposting or what have you. I think that was a portion of that case, if I recall correctly. So I guess
And
the
so
question.
so you're okay with doing that now, or is that still a problem? I realize I'm not. With adding that dynamic to this.
I would
alert.
say it depends on if there's going to be a statement that posting or reposting is the same as making the statement. I think that's different. Not saying that can't be done. I think we would maybe want to explore some analysis of the First Amendment issue there, but I think that's different from stating the holdings essentially of the cases, be them or dismissals. In those cases, the facts and the dismissals in those cases. It's a bit of a distinction, I guess, is giving advice that something does or doesn't violate the rules versus just providing the factual summary of what happened in a case.
But is this not an alert which basically says it's advisory only?
It
Which
does.
to me seemed like it was like took every tooth that it was meant to have. By the time I got to that sentence, like, okay, well, that's great. I can just ignore it.
We'll
So-
still get a prior restraint accusation, I'll just say, most likely. We did this, I mean, just posting this as an article did get some media attention. It could be construed to be a prior restraint on free speech.
Free speech. Good.
it's
We need some
chilling.
of those. We need some restrictions on free speech.
No, we just need, right, well, we need to, like,
Because people don't know what not to say.
well,
They
people
need a little
don't,
help.
people think that free speech, well, whatever, blah, blah.
I'm just saying, as a non-attorney, I'm just saying, I wish we could tell people what to say a little bit more, so they could be a
Well,
little
I
bit more
wish-
intelligent with
Yeah,
their
I mean,
comments. Yeah. Yeah.
right, I mean, I think we're abusing our free speech privilege sometimes, I think.
Exactly.
I don't know, anyway, I don't wanna get into that. Okay, so we are going, so we have that, this is the plan, we will definitely vote it out on the next meeting. Okay, so let's move on to the comments. To rules 3.6, 8.2, and 8.4. I forget, Erica, I know, I know that George Cardona had he had.
It's included.
So those comments, it was included, yeah, okay, I meant to look at that and I forgot. Okay. So these comments are basically the product of all of our meetings, and discussions from the past couple of meetings and our discussions with the judges. The judges did review these and agreed with them. So, this is, I think we actually basically drafted these at the last meeting. And so,
That's correct. There's no changes from what was approved by the committee at the last meeting, with the exception of adding an or that was recommended to clarify that if you look at 8.4.
C or C and D or something, yeah.
Yes, correct. So if you scroll down to 8.4, keep going, Angela. Thank you. Keep going. Right here. So if you look at comment 7 on line 20, it used to just say paragraph C, and now it says paragraph C or D. That's the only change since the committee voted on this in December.
Okay. And the C, so I think that was what George said, that it could apply to both of those subsections of 8.4. Okay, so I think we're ready to just vote this out then, since we already approved it the last meeting, unless anybody has any questions or concerns or things that they didn't think of before and think of now. I see no hands. Nope. Okay, great. So let's do oh no, I gotta move. Do I have a motion? To vote it out?
Vote it out.
Right. Thanks, Bill. Second. Thanks, Raquel. Okay, so this is to vote out for public comment.
Before we vote, just 60-day to come back at the May meeting, does that?
Yeah, and then it goes to the board, or does it go to the board simultaneously?
No, it would go to the board after, assuming that COPRAC doesn't want to make any changes based on the public comment, then it would go to the board. Otherwise, COPRAC could make changes. Or say, here are some areas that we think you should change before it goes to the board and do it in that fashion.
Okay, so sorry, now I'm jumping to my next question without letting you finish your answer. How are we communicating this to the public? Do we have a preface, or should we have a preface, to explain what this is?
Yeah, it'll go out the same, so there's no staff agenda that typically accompanies things that are issued by the Board of Trustees at the public comment level. But what it would include is we could provide a little bit of context, and staff could do that, or this committee could direct the working group to prepare that before it's posted. But essentially what is for comment is the rules themselves, and then how this is disseminated is that the request for public comment on the rules would be posted on the State Bar website. All public comments go in the same place, so it's on the public comment page. And then it would be distributed to COPRAC and other email lists, essentially, that we have of interested stakeholders on rule changes and so forth.
Right, but the description will have a little bit of context and history and,
yes,
whatever. Okay, let's take our vote. 60 days is good, yeah.
I'll take the vote. Ollie, Brown,
Yes.
Coleman,
Yes.
Guzman, Mercado,
Yes.
Mohebi,
Yes.
Munoz,
Yes.
O'Reilly, Poindexter,
Yes.
Ravi, Riley,
Yes.
and Shivers.
Yes,
Okay, it's unanimous, so the motion carries.
great. 2 things voted out today. Good job. Okay, so we did 4.3 already. Now we're on to 4.4, which is the flat fees in term. Did we already talk about this? Draft flat fees and termination, possible approval for, oh no, we didn't actually.
Brandon, right on you.
Well, I've been lurking. So we got 2 public comments on this that were very interesting. CLA did a very thoughtful comment, wordsmithing with very useful suggestions to clean up imprecisions in our approach. We got another comment, and I always pronounce his last name incorrectly, from Nick Migliaccio, if I'm saying it correctly, but I've worked with him in the past, and he is extraordinarily experienced. He was on the MFA committee. We overlapped for a little while, and he's done hundreds of these. And he disagrees with our approach to the extent he views it as saying this sort of milestone method is the only or exclusive way to figure out what fees are earned in flat fee cases. And he prefers giving fee arbitrators much more discretion, using the lodestar approach when appropriate, and just giving them more options. He's got a very thoughtful piece. Not sure I agree with it or not, but what I am sure of is that up until very recently, I was the only person on this particular working group, and I shouldn't be deciding by myself which approach I agree with. So I look forward to working with Nima and Raquel, sort of really fly specking these comments and seeing if it changes our approach at all. I will say that I've always been slightly uncomfortable with this issue, which is why, number one, it needs a fee arbitration advisory, but number two, I mean, the reason is there's just no real authority out there. I mean, there are people that take the view if you contract to complete services for a flat fee and you don't complete those services, you have not earned your fee, full stop. We have not taken that view, but we haven't really engaged with it either. So I think, now that we've got some people on the working group, we should take some time with these comments and talk it through. And if anyone else wants to join, that'd be helpful too, because, it's the people who did all the work on this are gone. Ken Bacon started it, Joel and Elizabeth took it further, and now it's here. And when the comments come in, the drafters are gone. So we should chat about it further. That's all I've got to report.
Erica?
And I'll just note for a little context, I think the reason why things take so long is that if you'll recall, this was voted out because the committee wasn't comfortable with a requirement about explaining why funds don't have to be held in a client trust account in a flat fee situation, including the seizure issues for attorney's fees. And so the reason it was sent out for public comment was not addressed, at least in my reading, at all in the public comments, maybe in CLAs, but not in a substantive way. And we now have public comments on the actual merits of it when it had to go out on this little tiny issue, and it's now back to being about all of the issues.
Right. So we are reinventing, or at least re-examining the wheel.
There was, I didn't read them, but maybe Erica, you saw them. I don't know, Brandon, if you're on April, but there was a listserv exchange about, I think this opinion, because Joel was talking about it.
Interesting. Look.
Yeah, they were talking about, so I don't remember, I skimmed it, but they were talking about, the whole flat fee issue and depositing in the trust and that sort of thing.
Well, the interesting thing is that literally was not see, this is an arbitration advisory, so it doesn't have to address that issue at all.
Right.
But it was a very important issue to Ken and Joel. And they wanted disclosures that went beyond what the rule expressly requires.
Right.
And my personal view is there's enough new ground to cover substantively. We could sidestep that issue entirely. That doesn't need to be part of an arbitration advisory, but it was important to the drafters when the public comments went out. Yeah. Erica, if I'm describing that correctly, I'm not sure, but that was my thinking. I don't know that the arbitration advisory needs to take any position on what goes in a trust account or what doesn't. In an arbitration advisory, now this is the weird thing about having COPRAC do these arbitration advisories, because they are used for different purposes, more so than they were when it was just the MFA committee. But a fee arbitrator doesn't need to really analyze that issue. They just need to figure out how much fee was earned, if any.
Right.
Well, and I think it raises one other interesting question is, since this is focused on that, does it still sit as an arbitration advisory or does it sit as a ethics opinion?
And if so one of the interesting things is and I'm not sure there's anything formal about this, but the MFA committee was just really pragmatic. So if there's really no controlling authority, we would just come up with a common sense approach. And I think historically they did that a lot. And a lot of people think those are very, very beneficial for the public. But that's not usually COPRAC's approach. There's sort of a split as to whether COPRAC can talk about things without authority. So this little arbitration advisory has become very fraught on those points.
Well, but it is a draft opinion at 20.000. So is it an endorsement or is it an opinion?
It's a draft opinion. So I think it's not a draft arbitration advisory at this time. So
didn't it start as an arbitration? I'm trying to figure that out.
I don't think so.
That's really interesting. I thought it was always being treated as an arbitration advisor, but maybe I'm just completely confusing it with something else.
Could be. Okay, so, what are we doing with it? So we're coming back after, so you guys need, oh yeah, you need to figure out which path you want to take, and so you'll bring it back in the
Yeah,
March
we would,
meeting.
we'll bring it back and make a recommendation to the full
Oh,
committee
but,
discussion.
oh, and you have new working, okay, because we kind of talked about this, so you have new people on the working group committee,
Yeah,
right?
we have 3 people, but we'd welcome more input. I mean, I think there's honestly like a big discussion to be had here, so.
Novella?
Yeah, I was just curious what the other options were besides the lodestar approach and milestones.
Well, the only one I know about is sort of an absolutist approach. Like if an attorney does part of the flat fee work, and some of this would turn on whether the attorney quits or is fired, right? Is the attorney prevented from completing the task? But if an attorney just gets halfway done and quits, is that of any value? Has the contract been satisfied at all? Should they even be entitled to quantum merit? Because it's going to be really hard to go out and find someone to complete that task for half the fee. It doesn't really work that way, you know? And so did the contracting attorney form a contract where they only get paid when they complete it, as it says, you know, I get paid X for completing Y. But that's one of the approaches. I'm not really aware of, you know, much controlling authority that touches on this, so. But the objection, of course, to the lodestar approach is for people that are really budget conscious and can't afford it, they specifically, a lot of clients opted not to choose hourly fees. Like I can't afford to pay by the hour, but can we agree it'll cost X? Yes, here's the agreement, and it wasn't completed. Why do I have to pay anything? You know, that's one of the thoughts. But at the very least, is a lodestar approach appropriate? And I think one of the things that one of the public comments we got was suggesting is that an arbitration, the MFA arbitrator needs a lot of discretion there. Maybe there might be some circumstances where the lodestar would be appropriate. There's others where it's not. Now, he's coming completely from an arbitration advisory point of view, which might have helped skew my thinking into forgetting that it's an opinion. But you know, it's sort of a tough issue that we'll have to walk through. I don't know the answer to this, which I know is why the opinion came about, because nobody is aware of an answer. There's no uniformity to how it's approached.
Okay, I mean, okay, let's keep moving, because we.
I said you should join the group. You had something to say.
Well, I did, I mean, I was thinking like, I was thinking like, well, if you had milestones, doesn't that typically, you know, mitigate against even getting to a fee dispute, you know, because that actually, I mean,
Yeah.
so you won't even end up in arbitration because
Right.
you have the milestones, you have what the, you know, expectations are, as far as, you know, how much was completed and what's earned. Anyway, so, but I would like to, but I don't want to take on more than I think I can handle.
I think that's very smart as someone who is who made the mistake of joining every committee for a little while.
Yeah. Okay, on that note, item 4.5 is the ethics of in-house counsel. So I really want to get to the symposium, and we're already at 3:15. What I would like to, what I would like to do is make the change that I think needs to be done on this opinion and recirculate it with the working group, and then we can come back in March to talk about voting it out. So if you guys don't mind, we don't need to look at this opinion right now. Sorry, Angela. Or Erica. Okay. Unless, Neiman, did you have anything you wanted to talk about regarding the opinion?
No.
No, okay, good. We'll deal with it in the working group. a little bit more. Okay, so, and then 4.2, client file release and retention duties. We already talked about this one, right? When we were going through?
Yes.
I've already
so
forgotten.
it's okay. It will, the current version that was issued for public comment in 2022, plus those public comments, I think will be posted, and please read in advance of the March meeting, and it will be decided, in between that time as to, in consultation with, those criminal lawyers that have volunteered to look at this based on their input, if they think it needs changes, and if no one thinks it needs changes from them, as well as the working group and committee, then the question becomes, should it be reissued for public comment because it's been so long and not that many people weighed in, or should it be voted out to be adopted?
Okay. Okay, and then 4.7 is the arbitration advisory. That's you, Erica.
Yes,
right?
that's pending with
We already
myself and Emil, and it will be there. You'll have it back in March, and it should be ready to be voted out at that time. There's nothing substantive in the changes.
Okay. So now we're going to turn to the ethics symposium. Can we take like a 4-minute break, to bathroom break, and then we can come back and finish up with the symposium? Does that sound good? Okay. Okay, so we are back. We're going to talk about the symposium. Erica, you want to take it away?
Sure. So 2 things to discuss and hopefully accomplish. It was communicated to staff, and thank you for raising it, that the symposium is currently set for April 18th, which is Good Friday. And so we wanted to get the temperature of the committee as to moving it to April 25th instead. We haven't posted anything about it. There's no save the date posted yet, but we typically do that very soon. And so wanted to really check calendars for those who have volunteered themselves to possibly moderate. And then the other thing I'd like to accomplish is actually finalizing the moderators today based on preferences of those who indicated such.
Okay. I think it's fine to move it to April 25th. I'm free on that calendar. Dan's free on that date too. So does anybody have any objections to moving it to the 25th of April? No.
Neiman does.
Yeah,
Oh.
I will not be able to do the 25th of April.
And then Emil is also not present today, but he had volunteered to participate in the outside council. And then Carrie, I think you volunteered as well, and Raquel, and I think that's the group of volunteers currently.
I'll help with whatever you need.
Okay, so do we want to keep it on the 18th then? Because did you say that Emil was not available, or was everybody's available on the 18th, right? Is that what so we're worried about participation, really?
Correct.
Right.
I'm trying to think. It's not necessarily spring break for everybody.
It is, right, it's either before or after,
Yeah.
but it typically is the word I was gonna use is not a good word, but it's a non-working day for a lot of people.
Yeah, I mean, I think it's well, I don't know if it's even a holiday for us. It's not.
It's not a state or federal holiday, but as Raquel said, a lot of people do, I think, take it off, especially if they have people that are on spring break.
Mm-hmm.
If they're not working, they can attend the symposium.
Right.
Yeah,
it's not working.
they love to do that, Carrie.
And it's fully remote too.
It's
I mean,
wow.
I don't know what I can't gauge, like, really, is it going to impact participation? Is it offensive? You know, if that we have it on Good Friday.
Right. Which is for some a religious holiday.
I know. Well,
right?
when's Passover? That's but that's not, you know, really, well, you do take off. the
For
day.
whatever it's worth, we did inadvertently host it 2 years ago on a different religious holiday, and we did get feedback about it.
Positive
For one individual, yes.
and is there something, what about the 11th, moving it up a week? You
I like
pushed
the
it
11th.
back,
I like the 11th.
you could do the 11th, yeah.
Shoot, no, never mind. I was gonna schedule a mediation on the 10th, not the 11th.
Yeah, I'll be in New York for work on the 11th. And so I'll be traveling on the 11th.
So that's a no. You won't be available.
But
right?
I mean, I don't have to do the symposium. So if the 11th works for everybody.
Yeah, I mean, I think I missed my first symposium because I had something. I mean, not that we're encouraging you to miss but we need to
Yeah,
figure out
but if the
everybody's
11th works for
calendars.
everybody, then yeah, we should do the 11th. I just won't be able to participate.
So nominators must attend, and then everyone else I think is optional. And Angela must attend as well, and everyone else beyond that I think is optional.
And we don't have intelligence on Ali's availability.
We don't know Emil's availability.
Emil, yeah.
For whatever it's worth, it's just going to moving it a week earlier moves the deadlines a week earlier. So, which may not matter for people, but just less time to prepare.
Doesn't.
Well, so the week of the 7th through the 11th is my daughter's spring break.
Spring break,
But we're not going anywhere, so I'll be here. She just might be like laying on the couch in my living room. Okay. So
Does your daughter know?
I don't care. I'm available.
Does your daughter know she's not going anywhere? Or just you know you're not going anywhere?
She's going to the ethics symposium.
Yeah.
But she can dress up, and she can even dress up.
Yeah. I have a lot of work. I have a bunch of hearings and things that week too, but I'm available the 11th, 18th, and the 25th. So should we just take a vote whether we want to do it on any one of those days? I don't have a preference actually. So how do we want to vote? You guys want to vote on it? Yeah. How many?
I won't be here on the 18th.
Who won't be here on the 18th?
Two won't be here on the
Nima
18th.
and Vikita. Okay. So let's and what was wrong with the 25th?
I also won't be here the 25th. But again, the same
okay,
reason
right.
with Kara, I mean, if I'm not, I'm perfectly fine to miss it if
So you weren't going to be here on the 18th anyway, right, Nima?
That's right.
Oh, I didn't know that. Okay. So okay. All right.
Okay.
So to get you, we got to go the 11th. To get Carrie, we can't do it on the 11th. And then we don't know what Emil's doing. His availability.
I don't know. I mean, I think I would prefer the 25th. Sorry, Nima, even though I want you to participate.
Perfectly fine. Perfectly fine.
Okay.
You just said do more than me.
I'm sorry?
No, that's not me.
No, I mean, I think just given the other kind of considerations, the 11th is maybe a little bit too early. We have too many people out on the 18th. And so the 25th, we only have one person that can't participate, is all I'm thinking. So I think it's between the 11th and the 25th. So why don't we take a vote on either of those two dates? So, okay, Erica,
we don't know Emil's availability.
We don't know Emil
as well. Right. So there could be two people also out on the 25th.
Can we decide this by email? Or do we have to decide this at the next meeting, or can we decide it at the next meeting?
No, the next meeting is in March. It will be too late.
Too late. Right.
So what we could do is we could decide to move forward with whichever date the most people are available. So it sounds like the 15th is, it either needs to be the 11th or the 25th based on those who are going to attend. As far as the people who indicated their interest in moderating, they're in on a specific topic. It's Nima and Emil and Carrie who may not be available, and Vikita, I recognize that you offered to assist on any of the topics.
So, oh gosh. Okay.
Yeah, I want Nima on AI, right? Because that's what, because, shoot. So wait, Nima, you are not, so I think then let's just do it on the 11th. Then everybody's available on the 11th, right? And
Carrie's
that's
not
except
available.
Carrie is not available.
Carrie is not, sorry.
That's
but-
And
okay.
Carrie's moderating a panel too.
Carrie, what
we just-
panel were you on?
I had volunteered for the outside council guidelines one.
Outside council, okay.
So actually, can I just ask a question? So if it's on the 20, and it's fully remote, right?
Correct.
Right,
And it's only an hour and 15 minutes of time.
Okay, and
for the
what
presenter.
time would it usually, because, okay, so I have a annual like partners meeting thing that we have here, and that's in Florida at that time. But if it's only an hour and it's remote, then I mean, I
You
guess
could skip
maybe,
out.
yeah, I mean, maybe I can just try to make it, maybe say tentatively the 25th, and I'll try to make it work. That way so Carrie can be there. And you know, if for some reason I get an unmovable conflict, which I don't see why I would if it's in the middle of the day, then I'll just tough it out from a hotel conference room.
And you'll be
Okay.
ahead of us 3 hours, so that
Yeah.
would also help. We could, yeah, maybe, let's see,
Play with
no,
it, yeah.
Carrie's in LA on 25th. Okay, that could work.
Yeah, so we could do if you did the AI one, it would be the one right after recent developments. So it would be, like 10:30, 11:30, like 1:30 your time
Your
in
time.
Florida around that time.
But we can
Yeah.
also change the schedule too. I don't think
Schedule, right.
the
'Cause
times
if we
are
need,
set,
yeah,
the topics at this point. It's
Okay,
for the other speakers beyond the moderators that the moderators are going to help find, the sooner we can set the actual schedule, the better. But I don't.
okay.
okay, so we're going for the 25th, sounds like.
Yeah, let's do the 25th and then we'll have to, and then Emil.
Hopefully he works.
Yeah, if he can't, I think we're fine, because he's only on the in-house outside counsel, and we've already got Carrie
Carrie.
and Raquel, you two, right? Or this was your second choice? To moderate.
Yeah, I was on AI, I was hoping.
Yeah, no,
So then,
I know, I'm just looking, how come, so is there anybody else? The people who are moderating, well, okay, so the 25th, April 25th, the April
25th.
25th is the plan. Okay, good. Okay, now let's move on to moderators. We have the topics, right? It's recent developments, AI, in-house counsel, outside counsel, guidelines, and then judicial threats. So recent developments will be me, Dan, and Brandon. So that's easy. AI will be Nima. Let's put a pin in that one because the only volunteers we have are Nima, Raquel, Carrie, Emil. And that's it. Those are the only moderators who volunteered?
I just said I'll help with whatever you need.
And so the judicial threat, since Vikita worked on that, wouldn't
Yeah,
that be good for
no.
her? Yeah.
Yeah, I don't mind.
Not that I'm trying to volunteer you or anything, Vikita,
That's
but
fine.
I thought you were gonna be doing that.
Yeah. Listen, I'm just glad to be somewhere where it is stationary. I have some power. I don't have fires and nobody is
Yes.
sick again. So
Yes.
So
that's my
Amen.
threat.
Amen.
Vikita, why don't you and I do judicial threats? And then we need to get a judge on that.
I can
I
help
have
with
one.
that. Yeah.
Yeah, I got a couple.
Why don't you ask Elizabeth?
Yeah. Well, but she's too new.
She
I
is
think.
too new, but she's a great presenter.
Yeah.
Yes, good point. Good
No,
point.
I know. I mean, she would be great no matter what. Yeah, wait, was she on this working group? She was
She
on this
was,
working
yeah.
group.
She was, yeah.
And her
So-
partner is a judge, so maybe she's secondhand lived some of it too. But there's plenty of great candidates from
And
the
she had great comments and stuff too. Yeah, so Erica, we'll talk about other panelists on that one. But so Vikita and I will be the moderators. And then we'll get 1 or 2 judges. Does it matter how many can we get? Can we have 4? We can have 4. Yeah. Okay. Yeah. Okay, and then so the other 2, so we have Nima, Raquel, you wanted to do, is there anybody, Raquel wants to do AI, right? Is there anybody else that wants to do AI, or do either of you have any ideas for other panelists?
Yeah,
No?
I do.
Yeah.
Nima probably does as well, yeah. Oh,
Okay.
panelists, no, yeah.
And
2
then the
is kind
in-house-
of 2 is kind of enough for moderators. When you have 3, it's a little bit more challenging. Because you have more moderators than you have panelists, and you don't have a lot of time.
Did you do it last year, Raquel?
I
Did
did.
you moderated or you were a panelist? Okay, good. Okay.
Yeah, Brandon and I did it.
And it was the AI one, right?
Yes.
And we're just, I mean, I think we're not gonna revisit everything, but we're just gonna do an update based on everything that's been happening since last year, which is a lot on AI.
Last year was largely about the practical guidance itself.
Correct.
Right. And then this will also include crypto and cyber security. Okay, so we're good with Nima and Raquel on AI. Okay, and then in-house counsel, outside counsel, Carrie. And well, Emil, if he's available, but what if he's not? Is there do we have a backup volunteer?
For which one, Cassie?
In-house counsel, outside. So what was that again? We were gonna cover the in-house counsel opinions, but also outside counsel guidelines, and how to navigate outside counsel guidelines and,
I'll do it.
You
I mean,
know.
if you need a backup, I'll be happy to back up.
okay.
I know Mary Grace isn't here today, but I think that she would be interested in volunteering for it.
Okay,
So we can,
so,
sorry, Cassidy, go ahead.
no, I'm done. Go ahead, Erica.
I was just gonna say staff in between, we can reach out to Emil and confirm his availability because he did indicate a preference. And then if not, we can Bill, I'll let you know, and we can reach out to Mary Grace, excuse me, as well.
Sure.
To determine their interests.
Okay.
Cool.
So those are the 4 panels, correct? Okay.
So now that that's solidified, thank you. Angela will be sending deadlines to all of you. But let us know how we can assist. If you need help finding panelists, we can certainly assist with that. And then as the deadlines for materials and those types of things start to get closer, we can help with that as well.
Okay.
Nima,
was
do you
quick.
know how soon you will know what would be a good time for your panel?
Probably somewhere closer to April, but I'm happy, we can just set it and and then I can work around it. Earlier the
Okay.
better, probably.
Early, okay, so because I was gonna say if we can move, if we need to move it, we can. But or if it's already the second one, so that because it starts at 10. Does it start at 10 or 9? I forgot. The symposium starts at 10 or 9.
I'm checking.
Oh, okay.
I think it starts at 10, but let me confirm.
Yeah, okay. Okay.
Angela and I are now just racing to see who can find
I'm
it.
doing there first, Erica.
I have 10 to 4:30 in my
Last
calendar,
year
but
it was 9:30 to 4:10.
I was gonna say last year was 9:30.
it was 9:30. Okay. To 4:10. That's interesting.
It's because of the breaks and so forth. So the substantive panel is set for an hour, and then there's 15 minutes of questions, and then there's a little break between sessions typically.
Have we had an implicit bias? Have we had an implicit bias panel every year or something that satisfies that credit previously?
We had it last year, right?
Definitely
we
last
did have
year
it
and the
last
year before too, right?
So we've had
Largely
the
since
last-
it became a requirement, we have, it's not a requirement for the committee to do so. So now that
Right.
there's additional subfield requirements, arguably the AI one, depending on the content, can be in technology and the practice of law. That's a new subfield since the symposium last year. So the committee does, it used to be just ethics credit. And that was what the symposium was a day of ethics. But as the subfield credits have expanded, the committee has tried to do another subfield credit, essentially, besides just ethics, to get more interest.
Because I wonder if, implicit bias is definitely an issue in AI. I don't want to try to shoehorn too much into it, but if we're trying to generate interest to get practitioners to our symposium, it's something to think about.
in terms of making sure we include something about that.
If it appropriately
Okay.
fits,
It does.
Yeah.
Right? Yeah, okay. I'll take a note.
The judicial threats one could also perhaps be civility in the practice of law, which is also a new subfield credit requirement. That's
that's what I was
another one where implicit bias and other bias related issues could certainly be credit as well, depending upon what's discussed.
Okay, thank you for
And
a
our
reminder.
COE, the COE, the reporting deadline is not until April 1st now, right? At least for those who are up. Is that right?
Oh, they changed
yes.
it. Oh,
It's March
they changed
30th. You have to have the MCLE done by March 30th, Cassidy. So just to be very exact.
Yeah, thank you, because I was happy about that. But is everything moved to that date, or is there still a February 1st deadline for anything, like your fees?
It's all March 30th.
It's all March 30th, okay. Payment is due April, okay, good. Thanks, I'm glad.
Well, let me be clear. It's April 1st for payment, CTAP compliance, all of those things. But you have to have completed your MCLE the day before it's actually due, which is, in this instance, it's March 30th. The only reason that it's the 1st is because the 31st is a state holiday.
There's a third, okay.
Go with what's on the website.
No, I know,
It'll be safe.
I'm asking you my personal reporting requirements, so now that I have you here. Captive audience. Okay, I think we're done, right? So thank you all. This was a pretty productive meeting, I think. We got a lot accomplished. So thank you everybody for sticking it out, and we will end 15 minutes early. Yeah, so thank you. Have a great weekend, everyone.
Thank you.
Thank
Have a great weekend.
you.
Bye, everybody.
Bye.